Yes, Mr. Das.
Hello, item number 24.
It's okay, I think. Sharma.
Item 24, madam. I think it is come now.
It's coming very slowly. Anyway, it doesn't matter. We can hear you. Item 24, what's your
24,
prayer?
Your Lordship allowed me to mention the matter today to see the records of APS. That matter has to be heard finally today. Madam. The principal.
We understood that college.
Okay.
Have we informed Mr. Doctor? He was having the record probably.
Yes, I'll inform you.
APSC he record kindly inform Mr. Doctor. Where is that record in presence of him or anyone from any standing council of the APSC? Ask your colleague to be there.
Right.
Okay.
May I please? Item number 51, Lordship, but it has been wrongly listed, Lordship.
51.
Lordship.
Yeah, what's your prayer, Mr. Peter?
I think it has been wrongly listed, Lordship. I is for correction of typographical error, Lordship. Honorable the order passed with Lordship. Justice, Lordship. Bujabura.
Matter with okay. Mr. Kalita, counsel appearing for the applicant slash petition submitted. That matter pertains to correction some typographical error, the particular order passed by brother Honorable Justice Successors and wrongly listed before this court. In view of the above, registrar shall place this matter before the appropriate court for it. Yes, ma'am.
Wait, Your Lordship, I beg to mention item number 31, Lordship.
Yes.
I want to withdraw IA number 255 of 2020. This petition is filed for impediment of the newly incumbent. They were already transferred, so grant 4 weeks time to file fresh IA.
Okay, ma'am, please wait for some time. Immediately after mentioning, we'll pass this order in the eye.
Obliged, Lordship.
Yes.
First, my lord, I am praying for listing on motion matter on Wednesday.
On Wednesday, when did you file, Mr. Khan?
My lord, we have filed 27-1.
Which department?
My lord,
Elementary, secondary,
second.
inform the other side.
My lord, on Wednesday I am praying.
Wednesday,
My lord.
fine.
Maybe. My lord, this is admission matter. Madam. It is coming on the list, but it is not reaching matter. Otherwise, very urgent matter. So matter may kindly be allowed my lord, for listing on Friday, my lord.
6th, Monday. Yes, next.
Concept taken from the opposite party. Lordship, I beg to mention item 33. Lordship. Can agent is for the deal.
Yes.
My lord, that I beg to mention for listing my lord on some my lord, petition on admission, my lord. It is a matter pertains to provincialization, my lord, and my lord, this ongoing case is already disposed of, my lord, number of cases.
8.
My
8. Make a mention in the morning when it will be listed on 8th of February. Yes.
my
Lordship, I'm praying for listing of a matter, Lordship, on Monday, Lordship, 6th for admission. It's a provincialization of
Okay.
service.
Yes.
Met please, Lordship. On listing of a matter, contempt matter, Lordship. Family pension matter, Lordship, earlier allowed but not this, Lordship. Pray for listing the matter on 3rd, Lordship. I have some difficulty in
Not on 3rd. It will come up either on 6th or 7th.
Lordship, having some difficulty personally.
3rd, there is a difficulty. That's the reason I'm saying. Any date you want on 7th, 8th, 9th, whenever.
Maybe 9.
Fine. Yes.
Map is a lot. So, I beg to mention for listing of a petition relating to the non-payment of pension. It may be taken up on Friday.
Not on Friday, ma'am. It will come up next week. Any date.
And there is another matter also relating to selection and appointment of principal. Respondent number 6 has already been selected, but due to pendency of this petition, she has not been appointed, and she is going to retire in February last.
Is it?
Yes, Lordship. So,
Okay. On 8th of September, 8th of February, Friday.
Lordship, Thursday. It is Thursday because
2nd, we have large number of cases. Otherwise, we would have fixed it on 2nd. But we have large number of cases it will reach. So we can consider it on 6th. It will be better on having on 8th. We have less number of cases on 8th.
Lordship.
Yes.
All right.
May I please? Item number 2, Miller.
Item number 2.
Miller.
Yes.
Some instructions are to be taken, Miller, and I could not contact the petitioner, Miller. 4 weeks time, I can leave it, Miller.
Date to fix whether it is.
May I please, Your Lordship? My lord, I have filed an affidavit in opposition in connection with item 15, my lord, in the IA, my lord. Can it be, my lord, may I?
Okay, but yes.
Please, your lordship.
Have you some copies in the other side?
Yes, my lord. For listing of repetition, lordship, the meter pertains to non-payment of salary, lordship, from 5th of February 21 to till date, lordship. And we can be on 6th of February, lordship.
Okay, yes. Yes.
Lordship, I beg to mention for listing two WBC lordship. One is relating to the provincialization of service of a teacher, another is lordship, school assemblies.
On 9th of February.
Wednesday, lordship. They have Wednesday, lordship.
It's a new matter or old matter?
Old matter, lordship.
Wednesday will have number of cases that there is. Okay, try on Wednesday. We don't know whether it will be listed or not. Yes.
May I please, your lordship, I'd like to mention a listing of two contempt cases, my lord. And
When?
my lord, any date you, earlier date, two contempt,
Okay. On 8,
8. My lord,
Yes.
one petition for admission matter.
same date. Let
Same
it be.
date, on 8.
My lord, I beg to mention one exhibition for listing in the order column, my lord. My lord, the matter last listed on 26 September. After 4 weeks, has been fixed. But
Give the number.
yes, my lord. Petition number 6337 of 22.
2020.
22, my lord. 2022. 6337.
Okay, on 6th.
Yes.
Much older.
Listing a matter, my lord, on Wednesday, my lord, transfer matter, the urgent matter, my lord.
Okay.
Always.
May please, your lordship, matter, admission matter for listing. Last date was posted, last date posted on 10/1/2023 and was fixed after 2 weeks.
Not listed.
It was listed.
Okay, on 8th of February. Yes, next.
Please, your lordship, this matter may be come up for orders. Miscellaneous application filed for stay of the order issued by the Dibrugarh University.
6th. Yes, Mr.
I am praying for application of item number 49. There is a Lauzima course order. Person has to pass an order regarding service.
We'll have to get 2 o'clock.
Publish.
Yes, Mr. Chief.
My lord, my client is going to retire on March, my lord.
Give the number. Why it's not coming? Let's see. What's the number?
My lord, 6104 of 2022. It may be listed on the 1st of, my lord, it is to be listed, my lord. on the
61.
1st of February.
Okay. 61
6104 of 2022. 1st of February, my lord.
on 3rd of February.
My lord, the 3rd is difficult, then it on 6th.
It will be listed on 3rd of February. Don't worry.
My lord, I will not be available.
Who will your junior will be available?
No, my lord.
Okay, on 2nd.
Not 2nd, my lord. I will be in Imphal, so it may be on 6th, my lord.
Okay, on fine 6th.
Oblige, my lord.
Yes, ma'am.
May I please, your lordship, I'd like to mention two repetition. My prayer is for listing, my lord, for admission. It is a pension matter, my lord. Earlier two repetition matter was listed but not reached, my lord.
9th. Sorry, on 8th.
8.
What's your good name
And the
for the applicant? Public petition. By this application. The applicant as a petitioner preferred a contempt petition being COPC 351/2017 for non-compliance of the order dated 24/06/2016. It's passed by the 14 WPC number 6060/2015, which is pending for disposal. During pendency of said contempt petition, the respondents therein
Respondent number 1. Commissioner and Secretary of the Government of Secondary Education.
retired from service and the petitioner as applicant filed his application for implement of the new income tax. Banco is limited tax detail. However, while this application was pending for consideration, the other respondents as well as the applicant was to be implemented for which this application was filed, either detained or transferred from the said department, and new incumbents at the service. As such, on instruction of the petitioner, instruction of the applicant, Ms. Such and such is not pressing this application. Secondly, but if you file this application for implement of new incumbents as respondent continuous in said COPC number, prayer alert, release applications.
Obliged motion.
Yes, next.
For motion, item number 1. Earlier occasion mala this another court mala requisition the earlier file mala where mala whether the resolution is annexed or not mala. In this case also mala the resolution has not been annexed mala.
When the school was provincialized, Mr. Patrick?
My lord, school was provincialized. February, five notification are not annexed, my lord, but 6 February, my lord, 2021, my lord. Five notification, my lord. Annexed,
Heard. Mr. Chair, Patrick, counsel appearing for the petitioner. And Mr. P. and Sharma, standing counsel, Department of School Education for the response numbers
1, 2, and 4 loss.
1, 2, 4, 5, 4 and 5. It is contended by the petitioner that since 26/02/1998, he is serving as an assistant teacher in Akoi number 1 Akoi Kutia Lower Primary School. In the Rupakana education block of district Lakhimpur, since its venture stage. And whereas the respondent number 5 was appointed, or respondent number 5 joined the said school only on 13/08/2007. Earlier, when the headmaster of the said school submitted the relevant documents for provincialization of teaching staff of the said school under the provisions of the Assam Venture Education Institutions in the provincialization of services, Close Act 2011, amended in 2012. During its course, as the said authority did not submit the relevant documents of the petitioner, whereas submitted that of the respondent number 6. Number 5. The petitioner preferred a writ petition being WPC number 3455/2015, and the court on 28/09/2015, while issuing notice to the respondents therein, in the interim observed that until further order, the services of the said private respondent, respondent number 8 in WPC number such and such, within quotation bracket, present respondent number 5. By the official respondents number 1 to 5 therein, without considering the claim of the petitioner and also the leave of the court. By an order dated 07/06/2017, say WPC number 3455/2015 was disposed of. Considering the fact that, say 2011 Act being declared as an ultra vires, the judgment and order of a division bench on 23/09/2016 in WPC number 3190/2012 and other connected matters. Comma. Directed the respondents therein directed the petitioner that as in the meanwhile the Assam Education Provincial 2017 came into force have been enacted. If the petitioner is aggrieved by any further action on the part of the respondent authorities to any process of provincialization under the said 2017 Act, he would be at liberty to approach the court again. During the deliberation of the matter, Mr. Pargiri on instruction submitted that said number 1 Akoiputia Lower Primary School, the the borderline education block of district Lakhimpur was provincialized along with its headmaster P.C. Gogoi and the respondent number 5 Nampupai. Leaving out the petitioner who is senior to the respondent number 5 and without considering his better claim on the recommendation of the District Scrutiny Committee of Elementary Lakhimpur. Being aggrieved, the petitioner has preferred this petition. Mr. Party and counsel also submitted that petitioner preferred an appeal before the Commissioner Secretary Government of Assam in the Elementary Education Department for consideration of this case in February 2021 itself. School was provincialized in 21 or 20? 21. 21. February 20. And February 21 itself. 2021. Which is yet to be considered. Right. Provides for. As the case of the petitioner has not been recommended by the District Scrutiny Committee for Elementary Education, input recommended by the for provincial level service under the provisions of 2017 Act of Petitions. This writ petition is disposed of with the direction to the petitioner to submit an appeal before the
Directive.
chairman of this state level selection committee, represented by and from the director, Elementary Education Assam, chairman of the state level selection committee, on or before 15/02/2022. But in private, after hearing the petitioner as well as the respondent number 5, considering all the directives within a period of 90 days from the date of receipt. Stands this to
Order number 3, 4, and 5.
Mr. Saikia,
Lordship.
on last date when you not here,
Lordship.
we informed Mr. Chaudhary that the university in the other writ petition has filed its affidavit clarifying that it has adopted the 2018 notification of the UGC. Now, if some action to be taken, we're not saying that the chancellor is not having any such power to proceed with any such in this case. And very thing is this: if any action has to be taken, it has to be only in terms of that 2018.
Absolutely.
Right. So tell us at that what stage, because we have also been clear, because you have made it very clear that His Excellency the Chancellor did not say anything to take any action against the petitioner, but only communicated to the respondent university, and the respondent university on the basis of that has suspended the petition.
Not suspended. Suspension is a different issue.
No, suspended the petitioner from service.
That is a different issue altogether, Lordship. We have to distinguish between the action taken for the allegation of plagiarism, that is one part. The other part is the misconduct of him, where a DP has been contemplated now. There are two issues here. They are trying.
My Lord, before my learned Advocate General opens up the arguments, affidavit in reply is being filed today. So, in the original case, in the I filed by the university, so the matter may be taken up at 2 meters, along with that affidavit in reply.
You have filed an affidavit in which case?
Affidavit in reply
In the IA.
to the IA.
I file an objection.
IA in the original writ petition.
Is there any
9
new
zeros.
facts therein?
My Lord, some aspects are there. My Lord, the earlier petition, the entire issue evolves in the earlier petition. Then subsequent this 2022 petition, my Lord, that suspension order has been challenged by the writ petition. So, my Lord, some aspects are there, my Lord.
No, but tell us one thing, Mr. Fukan, since you are representing the university and the petitioner is an employee of the respondent university, can you take any action without following the 2018 regulation?
My Lord, the order that has been stayed by this honorable court, it is under that UGC regulation.
No. Earlier, because 2018 regulation is very clear.
My Lord.
If you have to take some action, these are the reasons, this way how a plagiarism will be considered.
My Lord.
And on the basis of that report of the committee, you have to take action on the basis of that against the concerned person, the scholar, or whatever you say.
My Lord.
Now, if you have to take any such disciplinary proceeding against such persons serving under the university,
My Lord.
you have to follow the 2018 regulation. Is there any other provision to initiate departmental proceeding against plagiarism of any such incumbent serving in the university?
My Lord, earlier I have indicated, my Lord, there are two routes.
That was
One is
the
regarding UGC regulation.
that we understood. But when this 2018 regulation came into force,
My Lord.
the question of other provisions are not there, because in the other affidavit filed by the university, have categorically stated that 2018 regulation has been adopted by the university. If it has been adopted, then only that is the regulation has to be followed.
It is regarding
Plagiarism. Plagiarism.
but the suspension is regarding misconduct.
Misconduct on the basis of what?
There are
LS plagiarism?
several aspects. That is why the
No,
affidavit been
misconduct
replied.
is on the basis of LS plagiarism.
One aspect, the repetitioner has taken time to file reply to that show cause notice. 8 days have been allowed.
No, that is whatever misconduct, we are not on that. The misconduct is on the basis of the plagiarism or any so called issued on the part of the provision, not filing within time. What kind of misconduct?
That is why that affidavit reply will be required. Since the chancellor of the university conducted an inquiry under Guwahati University Act. So that is another route. The first route is under that IAIP under UGC regulation of 2018. So that was stayed by this honorable court. But regarding that Guwahati University Act section,
how can you say that? The facts are very clear. Earlier, before coming into the force of this particular regulation, one Mr. A lodged a complaint against the petitioner before the Register of University. The matter was inquired into by two other persons.
2016 regulation.
Whatever. The matter was inquired into. And that chapter was closed, intimating the complainant. Right? Then the second chapter opened up. Now that particular complainant has written to the chancellor of the university. Then a discrete inquiry was initiated. And in that inquiry, the report was submitted before His Excellency the Chancellor. Right? The Chancellor has communicated to the university. Right? The application that was filed by the complainant before His Excellency was after the 2018 regulation came into force. If you are saying that the inquiry that was initiated against the petitioner on the basis of his first application was prior to the 2018 regulation came into force, and that inquiry was conducted accordingly by the university without complying the provisions of 2018 regulation. Right? And since now the new action that has been initiated with the complaint of the complainant before His Excellency the Chancellor, after coming into the force of 2019-18 regulation, and in the discrete inquiry, some allegations have been found to be proved against the petitioner, giving all the details, line by line details, which has been copied or whatever, and it was forwarded by the office of His Excellency to the Guwahati University. Right? Now, if any action is to be taken on the basis of that report of discrete inquiry initiated by His Excellency, if you have to take any action, you have to take action against which provision?
After receipt.
Because the 2000, the University Act will not come into the force if the university had already adopted 2018 regulation and no such inquiry has been initiated under the 2018 regulation.
From the very beginning, we are maintaining that stand. There are two routes.
Two
First
rules,
one,
when you adopt some particular regulation,
we have adopted that regulation, of 2018, and the IAIP was formed in January 2019.
right?
So, that is
And this application of the complaint was after
the
formation of that
promulgation
committee.
that UGC regulation of 2018.
So that is why, that is the reason we want to know, Mr.
When
See, probably the office of His Excellency did not inform Honorable Chancellor the provisions of this act or this regulation or formation of the committee. The Chancellor, being the Chancellor of an university, he has a right for some discrete inquiry, as you do in the other cases. But to be action taken on the basis of this discrete inquiry. Has to follow some rules. Which is that rule?
After the receipt of the inquiry report from the office of the chancellor, there are two routes open for the Guwahati University Authority. One, under UGC regulation of 2018, so that IAIP issued a so-called notice to the writ petitioner that has been stayed. The second one, under Guwahati University Act, under section 8, the chancellor would inquire into some like this in this section 8 of the Guwahati University Act. When that inquiry report is received by the university authority, then the other route under section 8 and 8B, the vice chancellor power and function. The vice chancellor will have to comply with the direction of the chancellor under Guwahati University Act. The first route has been stayed. The order is very clear. But the second one, regarding misconduct on the part of the writ petitioner, is still open. So, the Executive Council took some decisions. The matter again repeatedly referred to the University Authority under Section 8 by the Office of the Chancellor. Then this suspension order has been issued.
Okay, let us see if this suspension is not on the basis of this, or if it is something other misconduct. We'll see.
Lordship.
And the Supreme Court is clear, two proceedings can simultaneously proceed. That 5 judges constitutional bench and other recent judgments are also there.
Okay, we'll hear you at 2 o'clock.
Lordship, in this case,
Mr. Saikya, will you be available at 2 o'clock? Okay.
I'll make my.
Obliged.
Yes, in this case, lawsuit, the inspector of schools has been allowed to hold a charge of headmaster at present lawsuit of Panbari High School. That instruction I have detailed lawsuit. Moreover, in this petition lawsuit, he is apprehending that the respondents are contemplating to hand over the charge to the 5 respondent lawsuit. On apprehension, he has filed this petition lawsuit.
Mr. Huya, when the school was provincial?
My lord, it is a provincialization under the 2011 Act, my lord. 1/1/2013, the my lord, provincialization orders. My lord, may be pleased to find at page 36, my lord. With effect from 1/1/2013, my lord. Lord, at this moment, my lord, I am the lord fully qualified person, cadre of teachers, my lord.
When you were deputed to or BA?
My lord, immediately, my lord, after the provincialization,
Hmm.
the year, my lord, 2000, the petition order, my lord.
Where is the deputation order?
No, my lord, that is not available today, but I have been deputed, my lord. I have stated in the petition also, my lord. My lord, in paragraph 9, page 13, my lord, program, my lord, following all requisite formalities, my lord, took the admission of pursuing his required program, my lord, under the Banikanto College of Teacher Education, Lasit Nagar, for the session 2015 to 17. Accordingly, after pursuing the program, the petitioner successfully completed his course, and on completion of the same, my lord, certified that the petitioner passed the B.Ed examination. My lord, if my lord may be pleased to, my lord, want to peruse, my lord, I can produce that, my lord, if any order is available. Otherwise, my lord, he could not have in that fashion can gone for the B.Ed. Why? Now, my lord, observing all the formalities, my lord, I did the B.Ed, my lord. It is not in dispute, my lord. The department is also well aware, my lord.
Mr. Sisti,
Yes, my lord.
this, please come to rule 18, rule 14 of the 2018 rules. You have the book with you?
Yes,
Page 35 is the rule 14.
Yes, sir. Recruitment to the post of headmaster, public superintendent, and procedure thereof.
Now kindly read page 36, rule 2, 14.2.
To eligibility for the post of headmaster, public superintendent in high school, public high madrasa, as the case may be, shall be as follows. He must be BA, BSc, BCom with BTBA degree from any recognized university. In respect of Hindi teacher having degree qualification, the Hindi Parangat and the Nisanar shall be considered instead of BTBA. And he must have 10 years of teaching experience as graduate teacher.
So his 10 years period starts from 1st of January 2023,
Yes.
right?
Yes.
And for Hindi, what is the requirement?
In
Rule
respect of
2A,
a Hindi teacher having degree qualification, the Hindi Parangat or and Nisana shall be considered instead of BT and BA.
Mr. Mia,
My lord.
the response number 5 we are talking about. What is his qualification?
My lord, he had the, my lord, Hindi Parangat, and if my lord may be pleased to find the order, my lord.
He is a degree holder,
My lord.
right?
My lord.
And Parangat and Nisanar.
My lord.
Now, whether he is having Parangat and Nisanar or not.
Lord, he is having the Parangat, my lord. Of late, he has obtained, my lord. After me, my lord.
Doesn't matter. But that has to be, he is also having 10 years of service, right?
My lord. My lord. Seniority, my lord. Now the issue of seniority.
Is
My
from the
lord,
date of receiving graduate scale of pay.
both we have obtained on the same date, my lord.
That's what.
My lord. Both we have obtained. So seniority, we are in the equal footing, my lord. And secondly, my lord, if we go by the rule, my lord, from my limited understanding, I have taken care of and I have stated in my petition also, my lord, that this has been given, that the, in respect of the Hindi teacher, my lord, the word has been used, the Hindi Parangat and Nishanar shall be considered instead of BT and BA. Now, my lord, this consideration will come if there is no BT or BA degree holder in a particular school, my lord. Now, here is the case, my lord, when there is a, my lord, BT and BA degree holder is there, so, my lord, he will get the preference first, my lord.
No.
That is the intention
See,
of the, my lord.
This is categorized in a two-year.
My lord. And, my lord, the
See
whether,
the difference. Mr. Sisti also kindly consider this.
yes, my lord.
The incumbent must be a graduate, either of arts, science, or commerce.
Yes.
Which BT or BA degree.
Yes.
From any recognized university. That is for general teachers, right?
Yes, sir.
Now, in case of, that's why the rule very
Yes,
specifically mentioned,
for Hindi teacher.
in respect of Hindi teacher having degree qualification. So he must be a graduate
Yes.
of either science, commerce, but will
Yes,
have
sir.
Hindi, right?
Yes, okay.
The Hindi Parangat and Nishanar
Shall be considered
instead of BT oblique BA.
Yes.
So he must have 2 degrees. And it's
Hindi
not or.
and Nishana.
That means he should have Parangat as well as Nishanar. Because we have to read as such, we cannot interpret ourselves as an or, because that's what they provided. The apex code is very clear
Yes, sir.
in that circuit. So he has to have both. Only Parangat will not do.
No, my lord.
Parangat and Nishanar. We cannot read and as may. We have to read and as and with the add to Nisha Parangat.
Yes.
Later.
Anyway, notice should go registered.
Why you notice?
The only
That's all.
already.
Definitely.
Yes, yes.
You have already said
Yes,
somebody
yes.
else has been given charge.
Yes, yes.
Heard Mr. ARV Learned Council for the petition and Mr. SMT 60 Standing Council, Department of School Secondary Education for the respondent numbers
1, 2, 3.
and Mr. ILM Standing Council NCT for the respondent number 4.
My lord, disposing, my lord. Lord, I am the only person, my lord.
No, that they will consider.
My lord, my lord.
The petitioner submitted that while that he joined as an assistant teacher, he being a graduate, joined as an assistant teacher on 01/11/1996 in Panbari High School District, Kamrup Metro. On being appointed by the headmaster, come secretary, the said school, pursuant to resolution dated 13/10/1996 of its managing committee while it was in venture stage. The petition number 5, graduate and Praveen also when appointed, was also appointed as a Hindi teacher.
Lord, I am the petitioner, my lord. I have the BEd, the respondent, my
Hindi teacher in the said school pursuant to the resolution adopted by the managing committee of the said school on 22/12/1991, pursuant to which the said respondent number 5 joined as Hindi teacher in the said school on 22/12/1991 23/12/99, while it was in fancy stage. Said Panbury High School, along with one headmaster, 3 graduate teacher within bracket arts, 2 graduate teacher within bracket science, 1 Hindi teacher, 1 Sanskrit teacher, 1 junior assistant, and 1 grade 4. Altogether 10 teaching and non-teaching staff. Services of subject were provincialized by the respondent authorities in the secondary education department with effect from 01/01/2013 under the provisions of the Assam Provincial Education Service 2011 Act as amended. Pursuant to such provincialization, the service of the petitioner as a second graduate arts teacher and that of the respondent number 5 as a Hindi teacher was provincialized with effect from 01/01/2013, considering their date of joining as 01/11/1996 for the petitioner and 23/12/1991 that of the respondent number 5. After such provincialization, the petitioner obtained master degree in arts from Krishnakanto Handicap Open University in the year 2015, and also obtained B.Ed degree, 2 years B.Ed degree as a regular student, as a regular candidate from Manikanto College Teachers Education in the year 2017. Further, the respondent number 5, after provincialization of his service under the 2011 Act noted above as amended noted above, obtained Parangat in Hindi the headmaster of said Panbury High School retired from service headmaster in charge. Name is namely Ranjit Basumatari, retired from service on 31/12/2022 on attaining the age of superannuation. The petitioner contended that he being the only eligible candidate having the requisite eligibility criteria for the post of headmaster in any such provincialized secondary schools under the Assam, under the provisions of the Assam Secondary Education within bracket provincialized schools bracket closed rules 2018. The respondent authorities should allow him to serve as the in-charge headmaster of said such and such high school, district Kamrup Metro. Read this petition, listener, amongst others, for a direction to the respondents, respondent authorities in the secondary to allow him to hold the charge of such and such. And further, as the petitioner fulfills all the requisite eligibility technically to hold a charge, headmaster of said Panbury High School, district Kamrup, he on 18/11/2022 submitted representation before the inspector of schools, Kamrup, to allow him to hold such and such liquor, considering entire aspect and his educational qualification, which is yet to be disposed of. As in the meanwhile, such and such, the headmaster in charge of St. Banbury High School, Sri Ranjan Pusamaturi, retired from service on 31/12/2022 on attending days of superannuation. And the respondent authorities in the secondary education department is yet to allow the incumbent concerned from Satchan Banbury High School to hold the charge of headmaster of the said school. The petitioner has preferred this petition on 21/12/2022, staying amongst others to allow him to hold charge to perform review. Next letter. To direct the respondent authorities to dispose of the representation, directly dispose of his representation 18/11/2022, pending before the inspector of schools, Kamrup Metro. Further, the respondents in the secondary education department to do the needful for the purpose of preparation of the graduation list of the graduate teacher working in the various higher secondary schools under the inspector of schools, Kamrup Metro, for the purpose of regular promotion of headmaster in higher secondary schools. And to make necessary arrangement. To purpose of necessary to make necessary arrangement for appointment of regular headmaster. The state government in the secondary education department, effect from 10/10/2019, brought into force the Assam Secondary Education within bracket Provincialized Schools Service Rules 2018. Comma. A statutory rule under Article 309 of the Constitution of India, regulating the recruitment and the conditions of service of the teaching and non-teaching employees appointed to Assam Secondary Education within bracket Provincialized Schools bracket Post Service. Rule 14 of the said 2018 rules reads as follows. Sub-rule 2 of Rule 14 relates to eligibility for the post of headmaster of superintendent in provincialized high school of high madrasas. Rule 14(2) within bracket A provides that the incumbent for the post of headmaster, regular headmaster of headmaster, superintendent, headmaster, regular, such and such, should be a graduate in arts, science, commerce, with PT, BEd degree from any recognized university. And in respect of Hindi teacher, having degree qualification, the Hindi Parangat and Nishanar shall be considered instead of BT and BEd. Further, Rule 14(2)B provides that in case of any secondary school, the graduate assistant teacher having 10 years of teaching experience shall be included the cadre of assistant headmaster. No, for the post of regular headmaster. Not any clear. In the case in hand, both the petitioner as well as the respondent number 5 completed 10 years of their service as a graduate teacher on 31/12/2022 as their services were provincialized under the provisions of said 2011 Act amendment with effect from on such and such date paragraph on 20,040 by order dated 22/09/2014 issued by the Director of Secondary Education Assam, giving the effect of provincialization from 01/01/2013. It is well said that even for the post of an in-charge headmaster, a candidate must have, the incumbent must have the requisite eligibility. Full stop. Mr. Sister Standing Council Secondary Education and Instruction submitted that on retirement of the earlier headmaster in charge of said Panbari High School, who retired from service on 31/12/2022 alternating the age of superannuation, the Director of Secondary Education Assam by order under number GB-EST/A/PPP/FP/49/2022/23 dated 17/01/2023 allowed the Inspector of Schools, Kamrup District Circle, District Kamrup, Guwahati, to hold a charge of headmaster of said Panbari High School, District Kamrup Metro, with financial power to draw and disburse the salary, etc., of the staff of the school under FR 49(C), clarifying the same is a purely temporary arrangement. In the event of any decision taken by the responding authorities in the Directorate of Secondary Education to allow any senior teacher of the said Panbari High School to be its in-charge headmaster till regularly selected headmaster is appointed in the said school, the authority is concerned only after assessing the seniority as does the requisite eligible qualification and requisite eligibility to hold a post of headmaster in terms of say 2018 rules from amongst the teachers of say Bunbury High School. Shall consider to appoint, allow it, such for to hold the charge, say headmaster of the said school. Further, the respondent authorities in the secondary education department of the state may prosecute, shall prosecute the process of selection and appointment of regular headmaster in provincialized secondary schools of the state under the provisions of the state 2018 rules, if there is no impediment in place, comply with this. With the above observation directions, stands disposed of. Copy of the order dated 17/01/2023 of the Director of Civil Education Assam, placed before the court by Mr. Sesti.
My lord, the exercise of consideration, my lord, within a time limit.
How you ask the
My lord,
authorities?
that may kindly be given, otherwise.
See, we
my lord,
have
it will-
put, we will not say the given time, Mr. You can understand. We do not know.
My lord, then my lord, they will not proceed, my lord. Within a
Let us see.
minimum 2 months, time may kindly be given, my lord.
Shall proceed. That's all.
My lord, kindly, my lord, otherwise it
See,
will not have any effect, my lord. They will keep it pending, my lord.
They cannot keep the matter pending. There is a judgment of this court already.
No, my lord, I am
Long
not.
back. Find out that judgment. It is there.
My lord, if
When
I
this
come with-
2000,
Kindly, my lord,
Listen,
2 months or 3 months will suffice, my
listen,
lord.
when this
As-
2012 Act came into force,
My lord.
there is a big history. In a particular order before 2012 coming into the force, in one of the repetition, this court, one name of this court, Honorable Justice Gogoi,
My lord, no,
passed
my
a
lord.
detailed order
My lord.
because it was found that prior to that,
My lord.
only for once there was a process for selection of principal and headmaster,
My lord.
and it was challenged and nobody could be appointed. And there was a promise made by the Advocate General of the state to bring a new rule. And that rule never came for more than 17 years. At that stage, one of the teachers was to retire from service, file an application before the court. That this was the promise made by, as you know, the promise made by Advocate General is a court.
Is a, my lord,
It's
that, my lord, I
bonding
know.
duty of the state government, not by others,
My lord.
right?
My lord,
So, because he holds a cabinet post,
yes, my lord.
that's the rule of law.
Constitutional body, my lord, he is the constitutional body, so he
So
is.
after that, when
My
it
lord.
was not brought into force,
But my lord,
an
if in
order
this
was
case, my lord.
passed, it was not complied with,
My lord.
contempt petition was moved,
This is
giving a
contempt-
direction that such rule shall be published on or before 14/12/1993, probably not 1993, or maybe I forgot what was that.
My lord.
Then on 12th of August 2003, if I'm not wrong. It should be 12th of August 2003. That direction was given up to 14th of August, because otherwise to personally appear on 16th of
My
August.
lord.
Then the 2000 reel was published because the entire thing was published because of that particular order of the court. There, in that particular case, the court observed when there is a specific provision in the Act or rules that the concerned authority shall find out the post that are going to be vacant in the next year for the post of principal or for headmaster, assistant headmaster, superintendent, vice principal. As provided in that, it is the bounden duty of the respondent authorities to comply with this. they cannot keep it for that purpose
Pending, my lord.
pending for a long period.
No, my lord,
Right.
my lord, with
So
all
that
respect,
was
my lord. My lord.
1 year more means it will come for the next year.
Next time.
If it is in the 2022, it's over. So that in the end of 2022, it is the duty of the inspector of schools
Do not
for each
carry out the
district
exercise, my lord.
to carry out the exercise
Fine.
and to recommend it to the
No, no, my lord, I am here
gradation
for
list.
my charge, my lord.
No,
Now,
that is the reason I'm telling you.
my lord.
Take out that judgment. That's a rule of law.
My lord, if I come for a contempt, my lord will not accept my contempt.
No,
petition.
not required. Take out that judgment. But the observation is very specific.
Kindly, my lord, 2
That
months or
provision
3
is already there in 2018 rules, Mr. Mayor.
Kindly, my lord, 2 months or 3 months limit.
We cannot set the time. That's why I am saying that court has already set the time. Go to that judgment and find out.
My lord, my lord.
And
I
Mr.
can-
Sisti, it is your department who has act on that because that was the specific direction. Take out that file when the 2003 rules came into force, you'll realize what are the case numbers. Yes, next.
7, item number 7.
My lord, in this case, it is a matter of provincialization, my lord. My lord, what has happened? My lord, in the earlier also, this petitioner approached before this honorable court that when my lord, it has been recommended, then this honorable court has held, my lord, that it should be constituted or considered as a deemed provincialization. My lordship has already gone through such order, my lord. I have annexed the order at page 95. And on the basing on this principle, my lord, and the ratio of law fixed by this honorable court, my lord, the present petitioner has approached before this honorable court, my lord, at page 95, annexure 20 is an order, my lord. My lord may be pleased to skip the first few part. And my lord, at page 98, paragraph 4, my lord, by quoting the, my lord, which the judgment which we relied on, this honorable court has directed that in view of the above, the present petition is also disposed of with a similar direction to the respondent authorities to provincialize the services of the employees of the petitioner number 1 so and so school after making the necessary verification that the names of the petitioner number 1 employees have been
Okay,
included.
then what happened?
My lord.
Then
Then,
what
my lord, we
happened?
made this order available
Representation.
before the government by, my lord, submitting representation. It has not been complied. Contempt case had been filed, my lord, at page 101. Notice had been issued, still pending, my lord. Nothing had been done. Then this communication starts, my lord. This from page 103 to, my lord, page 108. Now, if in, my lord, may be pleased to take up the page 108, my lord. Herein it has been said, my lord, that with reference to the subject cited above, I have the honor to inform you that the inspector of school was directed to submit a detailed report via his office letter number so and so dated so and so, and the senior counsel has also been required to file an appeal before the honorable high court's order dated so and so, and the dated 1st of June, copy enclosed as flag B. So, my lord, this is the last communication. The matter is now resting there, my lord. It has not proceeded further. Neither they are allowing us, nor rejecting us, nor complying with the order, my lord.
Okay, okay.
So, my lord, may issue.
My lord, right.
Listen, listen, sister.
Yes, my lord.
This is an official communication lawsuit by the director to the secretary for filing an appeal. Now, can it?
They can
also
file
filing
an
an appeal lawsuit.
Hard, Mr. Your opinion and counsel appearing for the petition. And Mr. SMT Sisti standing
Or
counsel.
all of them. One.
Department of School, then back at second for the respondent numbers. 1. Petition number 1 is Gerzai Palm Adolso High School. Headmaster Educational Institution. Headmaster Secondary School. At Roha. In the district of Your document says Koliabor, then it was made Roha, so do not know where it is.
My lord, it should be Koliavar, my lord, not Rohan.
See, come to page number 65.
My lord. Where's I come out of the high school? Yes, my lord. Lord, the
Koliavar
name
and-
of the LSC is Koliavar, my lord. And the name of the institution with postal address, my lord, is but in annexure, page 70 is also, my lord.
Yes.
Page 70 is the letter of the director and the table annex, my lord, at page 71. LSC has been shown as Kaliabar, my lord.
No,
They
and
have
Koliabor
mentioned-
LHC, Legislative Assembly Constitution of Justice. And the petition number 2 is the headmaster of the site, which is still in the venture stage. For provincialization of teaching and non-teaching staff of the site, opposite the German high school. Come on. Two classes within the class 9 and high school. Though the district scrutiny committee for secondary education, Nagaon district, recommended the name of petition number 1 school for provincialization under provisions of 2011 Act of Amendment 12. Considering that the Board of Secondary Education Assam, by an order dated 20/07/2013, recommended its date of giving effect of its registration with effect from 01/01/2005. But the name of the said school was enlisted for being not eligible high school for provincialization under section 4 within bracket 1 of Provincialization Act 2011 as amended in 2013, as the said high school did not obtain recognition from the government while the said 2011 Act was in force. Being agreed, such non-provincialization of the teaching, not teaching staff of the said such and such school. Its petitioner, it's like, the petitioners preferred a writ petition on WPC 781/2020. Or provincialization of such and such. Right. And they said the petition was disposed of by the court by order at 07/02/2020. Allowing the respondent authorities, directing the respondent authorities in the secondary education department to provincialize the services of the employees of said Garjaipa Madrasa High School after making necessary verification that the names of the petitioners, names of the petitioners of the said names of the employees of the said school had been included in the schedule to the Act in terms of Section 4 in Bracket 1 of the said 2011 Act during its course. With the further observation that the respondent authorities shall carry out the exercise as expeditiously as possible, preferably within a period of 4 months from the date of receipt of certified copy of the said order. It is to be noted herein, the said WPC number 781/2020 preferred by the petitioner was disposed of on 07/02/2020 following the decision of the revision bench of this court rendered in the case of WPC number 9306/2019 disposed on 17/12/2019. In terms of that earlier writ petition was disposed of by Learned Single Judge, right?
Yes, yes, my lord. My lord, page 95, my lord.
That was disposed of
Disposal of, yes, my lord. Then, my lord,
9306/2019.
my lord, yes, my lord,
The
07.
9306/2019 again complying with the decision of the division bench, I think so.
No, no, my lord, my petition, my lord, Garzaipa
No, no, no.
Madrasa is at page 95, disposal of on 07/02/2020, my lord. My lord, may kindly
Complying
note
with
the page 95, my lord.
the decision
My lord.
of the court. 17/12/2019, passed in WPC number 9306/2019. Though the
It was-
petitioner number 2 representing the petition number high school submitted the copy of the order dated 27/07/02/2020 passed in their writ petition WPC number 78/2020. As the respondent authorities did not comply with the same, it preferred contempt case civil number 349/2020 among the erring officers of the secondary education department of the state, which is still pending for this court. So let us prefer a contempt petition litigation against the erring officials in not complying the said order dated for it, wherein the court on 24/09/2020 issued notice the respondents therein which is presently pending for disposal. We'll do one thing.
My lord.
Because the Annexure 27, Mr. Sisti, page number 107. Basis of the letter of the Director of Dean and Director of Secondary Education Assam. No, Director of Secondary Education communicated something. Possibly certain things are available in the other petition. We'll have a we'll call that one on Thursday. Release this matter on second, along with the records of WPC number 781/2019, prepared by the petitioners, disposed upon 07/02/2020.
Item 8.
This matter on 6/1/2020 was heard and instruction has been asked. Matter relates for non-releasing of student union fund and illegally had collected the exam center fees during COVID-19. That has not been also refunded. And therefore, Lordship, the student union approached before the Deputy Commissioner.
This is an higher education lawsuit that in the cause is from the secondary edition. That's why they are not here. Higher dates are copied to the secondary department office.
No, in the cause list, it is shown as secondary, but so far the cost factor is concerned, it is higher education. And copy also served to the higher education. Now, my lord, kindly have a look, my lord, page 29. The representation addressed to the Deputy Commissioner Dorong, my lord, which has been received on 19/12/2022. I had received number 6427. My lord. Here, my lord, allegation against the principal of the Kharupeta College, which is provincialized, my lord. And during COVID pandemic, the examination center fees has been received to tell, my lord, to telling 1,440 rupees. Twice. And from the student, total number of students 3,200. And also, my lord, allegation that the student union development fund also has not been released. And therefore, my lord, the union.
Heard Mr. K. Vial, learned counsel appearing for the petition. And Mr. S.F. is the standing counsel secondary education. As well as Mr. P.J. Fukan, standing counsel Guwahati University. Though the higher education department of the state is a party responding in the present proceeding. But it is seen from the notice that the petitioner served a copy of this writ petition to the Standing Council Secondary Education Assam on 02/01/2023, as well as Standing Council Guwahati University and Government Advocate Assam, instead of serving copy on the Standing Council Higher Education Department. Place this matter on 06/02/2023. In the meanwhile, petitioner shall serve copies of this petition, including the annexes appended to the Standing Council Higher Education, obtaining necessary acknowledgement. The registry shall reflect the name of Standing Council Higher Education in cause list under the respondent. In case
Worship,
of
the impugn
Standing
is,
Council
my lord, if not stay,
Secondary Education.
my lord.
Come back to us on 6th.
Nine. Possible for some time, senior person or another code here.
Mr. Gogoi, get hold of Mr. Gogoi.
He is coming.
Yes, Mr. Gogoi.
Well, I've got a parawise comment, not in a positive note, but I will file my affidavit lordship and thereafter consider.
What positive note? Second note.
According to them, my lord, it was uploaded. He was aware, my lord, he downloaded the admit card from that website, but how the appointment was not downloaded. There is a
In the order itself, we have indicated.
I understand, my lord. I have continued, but this
While issuing the order of appointment,
lordship.
though you have said to the incumbent, you have did not
Otherwise,
mention anything.
yes, communication will.
But while cancelling his appointment,
Yes.
you have given it to his original
Let me
address.
file my
What is
affidavit
this?
lordship will pass order.
Why? On that basis, sorry, you have to file an affidavit. Why to delay? And
Otherwise, I
the
can place the.
consideration is that you can file an affidavit. If you can show there is a net in all these areas. You know how difficult it is to get a net from inside the High Court. Even if you are sitting here, we cannot go out like you to get a net here. We don't get. So you can understand.
My lord. I conveyed one, my lord, finally.
As on date, no, that post hasn't been filled.
No, not filled up. After the FIB, probably we cannot. This will have to be now filled up if at all, my lord, by regular selection. Let it be on record, my lord, then on merit lordship may pass the order. I will file it within 1 week. By Friday, I can file it.
What is that SCRT rules? Was it published? It was published earlier. SCRT rules.
Oh, rules. I'm not ruling.
It was published.
Probably, well, these particular posts will not be covered under this rules. Right?
Mr. Gogoi, there is a particularly rule.
Madam?
I think that there is a specific notification of the government where
I've been informed, my lord, that it is a directorate ministerial service rule that is followed, my lord, in case of LD.
directorate establishment.
Yes, ministerial establishment rules. So they have adopted that.
73.
Yes, ma'am. That will be in the service manual. Otherwise, in the, my lord, service order of 2004, SCRT service order.
It's not there.
My lord, regarding joining, my lord, it has been stated that within 15 days from the date of receipt of the appointment order. In the present case, it says, my lord, from the date of issue. Not receipt.
No, the post of
But that will be there in the service manual. The service manual,
who is representing personnel department? The state government. This Assam Directorate Establishment Ministerial Service Rules 2013. Issued by the Personnel Department of the state. As per this book was last amended by notification, though it's a statutory rule under 309, but it was amended by notification, not been passed by the cabinet. It was amended in 2016.
2003.
16.
Oh, 16. Yeah.
Now, this is a statutory rule under Article 309, as I say.
Yeah.
Do you have a copy of this book with you?
No,
You don't have a copy. You're giving a copy. Are you open up more chamber? Anyway, no like it. read that rule 16.3.
16.3. Yes, sir. A
Please.
person shall join within 15 days of the date of receipt of the order of appointment. Failing which, and unless the appointing authority extend the period, which shall not exceed 3 months, in all the appointment orders shall be cancelled.
Right. Now, receipt means whether receipt, just like you have seen in the CRPC and others, service of notice and other things, amendment, electronic laws, the evidence, all has been considered. Now, this is a statutory rules of recruitment.
Yes.
It has been adopted by the SCAT, Directorate of SCAT. In that circumstances of whether this provision has been made, amended has been made, that it will be only communicated through the website of the Directorate. That has to be clarified by you from the personnel department and tell us on Monday next. Right? And if it was modified, when, where any notification has been issued. Right? Just only keeping in mind that this is a Article 309 rule. By notification, it cannot be amended. Mr. Gogoi is aware earlier, the revision of big matter, and that thing was set aside.
There is a cabinet decision.
There has to, not a cabinet decision has to be through the assembly process. It has to be approved in the assembly.
Yeah.
It's not like that. Any amendment, not by notification. So tell us on Monday next. And Mr. Gogoi also tell us on which, when you have adopted this particular 73 rules by the SCI. For proper adjudication of this case. The state government, the personnel department, represented by its commissioner and officer secretary, the implemented as party respondent number 3. Petitioner shall serve request extra copies of this petition in next to Mr. MS. MSD does government advocate at Samsung has entered appearance on behalf of the newly implemented party respondent. During the deliberation of the matter, please pass on the book. Mr. B. Gogoi, standing counsel SCRT, submitted that the Directorate of State Council and Education Research Training have adopted the Assam Directorate Establishment within bracket Ministerial Service Rules 1973 for the purpose of recruitment of LDS/junior assistant in different under its directorate and in different basic training centers under SCRT in the state. Purpose of corporate. List on 06. Rule 16 within bracket 3 of said 1973 rules provides that a person shall join within 15 days of the date of receipt of the order of appointment, failing which and unless the appointing authority extending the period, which shall not exceed 3 months in all the appointment order, shall be cancelled. On the next date fixed, the personnel be department of the state, personnel department of the state, respond number 3, shall apprise the court as to whether said provision of sub rule 3 of rule 16 of the said 1973 rule has been amended as on date. Specifying the receipt of such order of appointment means issuance of any such appointment order in the website of the SCRT of the department concerned. Including the department directorate of HCA. If any such amendment has been made by the personal department that pertaining to rule 16.3 of say 1970. The respondent person has placed the relevant amendment. The same day, I-06. Copy of this order to Mr. Das Broken Common.
Item number 10.
I have handed over the copies of the contract matter.
The contract was made on 2nd of August 2022. And that remains valid for another 1 year.
This is for which period?
Well, it was signed, made on 2/8/2020.
That's true. What is the term?
Term will be for another 1 year from August 20 to 29.
Mr. Nair.
Lordship.
Now, petitioner has placed
Term is not mentioned there. Lord.
7 of such contracts.
Eight also
Appointment of the
contractors.
petitioners.
8 petitioners.
No, 1, 2, 3, 4, 7. Right. Total 8. All signed contractual agreements signed on 2nd of August 2022. Out of which 7 are serving in Aziz Borua LP School and 1 in the Town High Madrasa.
Training centers, the petitioners are working, my lord, are reflected at page 11 now of the petition. There is a chart made, my lord.
No, that's
Otherwise, there are the work certificates given by the authorities. Those will also reflect where the petitioners are working right now.
no. These are the centers.
These are the centers, my lord.
Now,
Page-
Aziz Borua LP School
My lord.
or
The centers are
Town
not
High
the-
Madrasa are not the centers.
No, those are not the centers. The school centers are attached to the schools, my lord.
You know when these conditions are there, when these persons are attached to the schools, when after giving such training, these students become eligible
Yes.
to go for a common school, they are attached to the main schools. And if the students have already been attached to these schools, now if you see this order,
Lordship, can we see page 58 also?
no, that's
Detailed schedule is there.
that's a second. We have seen that.
Lordship, in the conditions, Lordship may sit down below, just
Ah.
below the table, Lordship.
Ah.
Serial number
We
1,
know that was in order. We remember that order when we passed.
Lordship.
There was a
Lordship,
very clarification.
so far as our assessment is concerned, Lordship, so far as Lakhimpur district is concerned, it will continue from April to January 23.
Hmm.
Schedule for mainstreaming of children by January 23.
Hmm.
Lordship, this is a completely centrally funded scheme, Lordship.
No, that is there because their agreement. If you have received the copies,
Lordship.
there also it is very clearly stated that it will be there till because they have been paid 6,500.
Lordship.
Hmm.
The provision of honorarium for ERA STC staff will be for the period as shown above. So far as Lakhimpur is concerned, Lordship, it is only up to January 23.
Well, with regard to the district of Kamrup, my lord, that the budgets were available till 30/11/2023. That was stated on instructions, by page 65, paragraph 7.
See,
So
Mr.
with
Munir,
regard to Lakhimpur
what
district,
we found at the reference is there the authorities have clarified that these number of students who are still under this NRSTCs are still going on under that particular training
yes,
and they have not completed the term so as to be attached with the regular school
Right.
students, right?
or
Now,
mainstream.
what we have seen here, these are all different NRSTCs. You have also named the centers,
Yes.
right?
Yes.
These are in various places.
Yes.
But this NRSTCs, which you have mentioned here with regard to the petitioners, we found that these are issued by the school, this agreement is by the school authority,
School management committee.
school managing committee, and the petitioners. Now, unless you can show that these particular, these two schools are the main centers of training under this particular scheme, how can we consider?
I could not follow your.
See, there are some centers, right?
Yes.
These are not lower primary schools. There are centers where these trainings are given, who are deprived of their elementary education on the age group of 5 to 14. They will be given special training and they will become eligible just like a regular student going to elementary school once they complete that training. Now here, your agreement, which you have annexed today before the court, is between the agreements, the order of this particular contract is between the school managing committee of two particular schools with the petitioners, not from the particular centers which have engaged you.
If I have understood, my lordship had asked for the
Agreement.
Yes,
Contract.
For the contract, so as to confirm whether the petitioners are still working or not.
Working as
training
volunteers,
education volunteers.
right? Education volunteers or education volunteers, whatever, in the training centers.
Yes.
Now, unless you show that these two particular schools are the training centers, how will you know? Because these are lower primary schools.
Lower primary school, madam. The students, these lower primary schools, madam, look after the training centers.
Where is
And
that?
this,
That is very much clear. You see from the scheme, you have an X, right?
Yes. Page 21 onwards, madam.
Page 22, clause 4.
Shiksha Karmi must be from the ward
No,
education committee.
Stop at page 22 or page 23.
23.
Roman clause 4 of clause B.
In the center. Center will be located in a public building available in the area. If no suitable public building available, the ward education committee should be requested to arrange for accommodation of the center. However, if the suitable accommodation cannot be arranged free of cost, an amount of rupees 500 per month can be used for arranging suitable accommodation for the center. It is clarified that by suitable accommodation, it is meant that the space at least 6 square feet should be made available for each child. While deciding the accommodation for the center, an effort should also be made to ensure that there is some open space or playground. This doesn't say what. So far as the other petition is concerned, my lord, the order of which is been annexed to this petition, my lord. Those were from the district of Kamrup. That is the only difference. But here the petitioners are from the district of Lakhimpur.
So there are materials placed before the court. That is
I'm
the
sorry
reason.
to say, Your Lordship, but I do not find any other such material on the order that has been annexed, Your Lordship. Only the statement, my lord, paragraph 2, petitioner 27 in numbers are serving as education volunteers as an additional education volunteers in different non-residential special training centers within the Kamrup
So
metropolitan
show
district.
us that you have been serving in such NRSTCs. These are LP schools.
These, yes, my lord, the
Show us that you are serving in the
certificates,
NRSTC.
certificates given by the authorities, my lord, have been annexed, my lord, page 30.
Hmm.
Page 30, my lord. Am I with your lordship?
Hmm.
Page 30. These are the certificates issued by the authorities, my lord. If I may read, my lord, this is to certify the Junmoni Fukon, care of so-and-so, an inhabitant of village Sapori Angao under so-and-so, Lakhimpur district, pin number so-and-so. She has been serving as additional education volunteer in Junaki NRCT formerly known as Jyoti Kendra from 01 February 2007 to till date. Aziz Borwa code is also given.
Now, where is that NRSTC? Okay, if you can show us
NRSTC, this one, my lord, Junaki NRSTC.
whether Aziz Borwa LP School having this particular UDIS is also known as Junaki NRSTC.
What?
We'll give it.
I'm sorry, your lordship.
Whether this Aziz Borwa Lower Primary School,
Yes.
it's a venture school or it's a provincial high school. Tell us.
There was also no material to show in the other petition that those schools were
Forget that.
NRCTs.
Forget that, Mr. Munir. You are
I'm sorry
saying
to say,
that
Your Lordship,
one of
but-
the petitioner is serving, see the certificates. One is Junaki, page number 30 is Junaki, same school. Center is Junaki, same school. Next is Gulab, same school. Third one is Gulab, same school. Then again, the fourth one, Junaki,
Same school.
same school. Then is
Akbar and
Akbar,
same school.
same school.
The Aziz Borwa LP
Again,
school.
the center is
Center
no
is
name.
Sapori Gaon NRC.
Sapuri Gaon, the same school.
Yes.
So tell us that whether
From
these are the
from these NRCTs, my lord, if the students
see
are
the
mainstream,
basic
they
concept
go
of
to these
basic
schools.
basic concept of these particular centers are that it will be confined to that area where they are residing, and from there they'll be attached to the nearby school. That's what the scheme is. You have to tell us whether these two particular schools have been defined as NRST centers of this Gulapi or
No, these two
whatever.
centers, these two schools are not defined as NRCTs.
Then-
Schools are not training centers, my lord. The centers are with these training
See,
centers.
Mr.
when
Muni,
these
we
child
are willing to help you, but you have to first
I'm trying to
establish
explain, my lord.
whether these particular Aziz Burwa LP school and the High Madrasa, whatever it is, the Madrasa Center is the NRSTC or not. There are 5-6 NRSTCs that you have mentioned at page 11.
NRCTs are different and the schools are different.
Schools are only two.
Schools, the students, my lord, after taking the training in the NRCTCs, they go to the schools. That is called mainstreaming. When they become eligible to cope up with the other students who have been going to the
Okay,
schools.
go through the provision and come back to us at 2 o'clock. If you are saying that students are attending this school.
Not school, my lord, the training center. Training center is Junaki. And when they are eligible for mainstreaming, they go to the school.
That's right. Now, where is your agreement between Junaki and you? The NRSS is the Junaki. Where is your agreement between you and Junaki?
Then add to my lord.
That is what we want, looking for.
Add to it.
May I submit, Lordship? Lordship will take up this matter on day after tomorrow, Lordship. I will also in the meantime take instruction whether those centers are working or not, Lordship.
But tomorrow, day after tomorrow will be 1st of February.
Yes.
Tomorrow, otherwise tomorrow was not a holiday, but a request of the bar, it has been made a holiday. So.
Tomorrow. That is why I'm doing day after tomorrow.
Then in that case, there will be some order in favor of the petitioners. If they are no longer serving, it's different. If they are serving and if they are required, they have to be
Why I'm
continued.
submitting lordship. You may say that centers are going on, but some authoritative instructions should come now.
First of all, we want to know, the thing is very clear. The petitioners have given some order of agreement, a contractual order. But these are issued by the managing committee of particular 2 schools in favor of all these 8 petitions. Now, whether these 7, 5, 6 centers which Mr. Munir has named is represented by these 2 particular schools, because agreement has to be signed between the ward center, head of the ward center, it is WSC or what is there, right? And the concerned education volunteer. But there is nothing like that.
Lordship. But what I am submitting, Lordship, so far as the schedule is concerned, Lordship, though these EVs will, services of these EVs will get terminated in the month of January 2023. From April 2023, school centers will again start, Lordship. That is the procedure. Every year, same thing happens, Lordship. In every year in the month of November and December, we take a survey, Lordship. And on the basis of that survey, we try to find out what will be the number of students in the next year. Accordingly,
So
we
it is
send a
not
proposal
mentioned.
to the
Difficulty
central
is that the agreement that has been given before us, how it is different in the agreement given in the others. In the other case, with regard to Kamrup Metro,
But
there
in
was a
Kamrup,
specific,
Lordship, it is your Lordship has categorically mentioned that in that order, Lordship. Therefore, till such finding is arrived by the respondent as observable, and considering the fact that 4903 numbers of OOSCs are still receiving their special training.
that's what, there was a
Page
specific
68,
instruction.
That
There
is
was
why
a
your Lordship passed that order.
Not only that, since the petitioners are serving and their names were recommended, because their serving condition, how they are serving, what is their prospect, that has to be considered by a committee. A committee was constituted. And the name of the petitioners are recommended to that committee.
Yes, Lord.
If you have remembered.
But
You
in
appeared.
this case also, Lordship, these petitioners will definitely get the job back from the month of April also.
We do not know.
Okay, that is what they are continuing since 2011, Lord.
And thing is this, their agreement doesn't expect that it's for 11 months, but that particular scheme is very specific. It is for 11 months.
No, in that scheme, Lordship. But here it is not mentioned. And the schedule at page 58, Lordship. At serial number 1, Lordship, down below. The provision of honorarium of NRSTCs shall.
Yes. You have given us a fair copy today.
Yes, Lordship. It is like the provision of honorarium for NRSTC staff will be for the period as shown above. Lordship,
So up to
kindly-
January 23, they will get the honorarium.
Up to January 23. So this is that is the schedule we are following.
Kamrup was till November 2022. It is that after the mainstreaming in the month of January, these training centers are sought to be closed.
Because no student will be there.
And they are contractual workers working for more than 10 years covered by wooden dust. That is the case.
See, Mr. Munir, the judgment of the apex is very clear.
Yes, yes, sir.
If somebody is appointed under a scheme and scheme comes to an end, even that judgment of the Honorable Division Bench and the Honorable Apex Court will become, will not be applicable. Only when a government appoints somebody on contractual basis.
In the order, my lord. I'm not
That's
saying
not the
on my
thing.
own, my lord. That is the observation of your lordship.
That's why the very clear that these things will not come. Anyway, let us see at 2 o'clock, then we'll make it clear. Yes.
Item number 11.
Yes, Mr.
The matter regarding merger or amalgamation of two LP schools.
Where is the amalgamation?
In this case, the order at page 40. Serial number 4, for EGS. Then our school is serial number 5, 2 number Panikati LPS with Luturidia LPs. Now you lost in kind time to page 26 the report.
No, go take one. What is that office memorandum of 3rd of August 2021?
31 July 2020, 17.
Where is your appeal?
We have not filed appeal. We filed a representation before the DO. That this page 30 the headmaster filed an application before the
Heard
DO.
Mr. D.A. Council appearing for the petition. And Mr. P.N. Sharma standing counsel. Department of School Elementary Education for response number 1, 2, 3.
1, 2, 3,
1 to 5.
5.
And MSP just government advocate Assam, response number 6.
There is an order of
The state government in the education department. File number ASC 481. /2016/164. Dated 03/08/2021. Formulated a scheme, namely Shiksha Khetra for amalgamation and merger of different schools. Pursuant to the said scheme, office memorandum dated 03/08/2021, and the approval of the Elementary Education Department of the state dated 03/08/2022. $50 numbers of lower primary schools, different districts of Kamrup district of the different 4800 lower primary schools have been 50 numbers of have been merged with 48 numbers of lower primary schools of Kamrup district, including 2 number Panikhati lower primary school, and Uppara EGS with Lutura Dia lower primary school. Petitioner by an order by notification dated 23/03/2022 under number EAA.75 /ML A capital /2021/490 issued by the Director of Elementary Education Assam on 23/03/2020. Petitioner claiming himself to be the president of 2 number Panikati Lower Primary School, being agreed with the amalgamation of such and such. I have filed this petition on 24/01/2023. Praying amongst others to set aside the notification number such and such issued by the Director of Education Assam in respect of number 2 Panikati School, which will be amalgamation of such and such. Press for number 5. 2. Directing the respondents to cancel, withdraw, phobia, giving effect to the same notification number such and such. To allow an such and such not to disturb the functioning of number 2 Panikati. The order of amalgamation, sorry, order of merger of petitioner school, which local LP school was of 23/03/2022. And after 10 months, the petitioner has preferred this petition from such date of merger. From the perusal of said office memorandum dated 03/08/2021 pertaining to the scheme of Shiksha Kshetra placed before the court by the Standing Council Elementary Education. It is seen that at clause 19, at its clause 19, they specifically provided that for any disputes arising out of the order of such amalgamation or merger under the said Shiksha Kshetra scheme, the aggrieved institution of the public may appeal before the government in the secondary or elementary education department as the case may be. Nothing variety or may be appeal if so advised. Mr. Sharma, understanding council. You have placed a notification, right? Also placed a copy of the order
10/9/2020.
number E.2257541/54/1 dated 10/09/2022 issued by the Secretary of Government of Assam in the Department of School Education, whereby a committee of 5 members consisting of a chairman, member convener, 2 members, and 1 technical member consisting of the Joint Secretary Government of Assam, the chairman, Deputy Secretary Government of Assam as a member convener, Director of Secondary Education Assam, and Director of Elementary Education Assam as its members, and the System Analyst of Sarva Shiksha Vision Assam as the technical member, to reconsider the order of amalgamation and mergers on the basis of appeal furnished by the concerned persons with regard to such and such in terms of said office memorandum dated such and such. Considering the correct petition in a period of 15 days. Recoverable certificate. In the event of a consequence.
If done, the status quo shall be maintained.
You have approached after 10 months and Mr.
Okay.
Kayom, you want the stay order now. It's not immediate. How can you
Status quo,
consider?
status quo.
You are coming because Gunotsav is there. You will get a certificate. That's all.
Okay.
12 and 13.
Yes, Mr. Das.
After setting aside of the appointment of the respondent number 4,
That order has been set aside by the division bench.
division bench, now Lordship may kindly see the division bench order.
Hmm.
At page from paragraph 9, Lordship, page 69.
Yes.
Mr. Nair has made an attempt to assail the recommendation made in favor of the writ appellant. However, since the learned single judge has not decided the claims and counterclaims of the parties on merit, so as to decide the question of legality and validity of the selection process insofar as the correctness of the assessments made by the selection board for the contending parties is concerned, We do not deem it appropriate to go into those aspects of the matter for the first time in the appellate court. For the reasons stated herein above, we are of the opinion that the impugned judgment and order dated 28/8/18 is unsustainable in law. We accordingly set aside the impugned judgment and order dated 28/8/2018 and remand the petition to be heard by a learned single judge express on merit. It is submitted at the bar that at present the inspector of schools is holding the charge of the principal of the school in question, and therefore there is urgency in the matter. Since urgency has been expressed by both the sides requesting for an early hearing and disposal of the writ petition, we direct the registry to list the writ petition being WPC 2638 of 2017 before the learned single judge as per the roster on 17/6/2022 for orders. In the meantime, the parties may extend pleadings facilitating early hearing and disposal of the writ petition. The parties are also granted liberty to make a request for expeditious hearing and disposal of the writ petition. With the above observation, this writ petition stands disposal. Now, Lordship, in terms of the earlier order, Lordship, is the appointment of the respondent number 4 was set aside on by the DSC Assam on 26/2019. Thereafter, Lordship, a review selection was held. In the review selection, Lordship, the petitioner stood first. Thereafter, Lordship, there is an inquiry going on, Lordship, with regard to allegation and counter allegation. In the inquiry report, Lordship, I have been exonerated from all the charges, and departmental proceeding initiated against me has been dropped. But the departmental proceeding initiated against the respondent number 4, a so-called notice has been issued. Lordship, may kindly go to the inquiry report, Lordship, at page 54. Lordship, may I read the inquiry report, Lordship? Submission of inquiry report regarding the allegation dated 24/6/2019 raised against Madhav Bhuya, lead and principal insert, and counter allegation dated 8/8/2019 against principal of Right India.
Mr. Das, which
Page 54. Lordship.
Yes.
And the Nagaon district. Pursuant to the order of the Director of Secondary Education Assam, communicated by letter number so and so, Kulendra Koltia, DDSC Assam, Provin Chandra Sharma, Inspector of Schools, Nagaon, Sanjeev Kumar Das, Internal Auditor, DSC Assam, on behalf of Malik Lal Dev, Senior Finance and Accounts Officer of this office, visited the Raidonge High Secondary School and the Nagaon district on 5/2/2020 to inquire into the allegation dated 24/6/2019 raised against Sri Madhav Bhuya, lead and principal insert, and counter allegation dated 8/8/2019 against Sri Mukti Das, principal of Raidonge High Secondary School under Nagaon district. However, the Deputy Commissioner of Nagaon did not depute his representative. Allegation against Madhav Bhuya. The Vice President of SNBC of Raidonge High Secondary School and a number of other signatories raised allegation against Sri Madhav Bhuya, lead and principal in charge of the school, regarding misuse of ₹1 lakh received during his tenure for development of the playground of the school, for which an inquiry was conducted by the Assistant Commissioner Nagaon, which was submitted to the Inspector of Schools Nagaon by the Additional Deputy Commissioner Nagaon by this letter dated 3/5/2017, but no action was considered on the inquiry report. Findings of the said allegation. A sum of ₹1 lakh was allotted to Raidonge High Secondary School by the District Sports Office Nagaon for development of the school playground during the tenure of Sri Madhav Bhuya as principal in charge of the school during the year 2016. The said amount was deposited to the school account in Assam Gramin Vikas Bank, Raidonge branch, bearing account number so and so. Again, 2.80 lakh was sanctioned by NSPC to the school for construction of toilet. In interaction with some other teachers of the school, it is observed that Sri Madhav Bhuya had spent the said amount of ₹1 lakh for development of the school. But when some other people tried to destroy his image by falsely alleging misutilization of the said amount, Sri Madhav Bhuya willingly refunded the said amount of ₹10 lakh to the school account bearing number so and so on 22/6/2016. Moreover, regarding the 2.8 lakhs sanctioned by NSPC to the school for construction of toilet during the tenure of Sri Madhav Bhuya as principal in charge of the school, it is found that the said amount was totally utilized for the purpose for which it was sanctioned as per records of cash book and disbursement records of the school. Regarding collection fees of ₹450 and 120 from the students, the allegation is totally false and found tally with the inquiry report of the Assistant Commissioner Nagaon. Now the counter allegation against Sri Mukti Das. The local public of the area of Raidonge High Secondary School filed petition dated 8/8/2019 submitted allegation against Sri Mukti Das, principal of the school, for misuse of the fund of ₹1 lakh, which was deposited by Sri Madhav Bhuya and destroyed of a number of valuable trees located in the school campus. findings on the allegations raised against Sri Mukti Das. During inquiry, it is come to notice that some of which 1 lakh was deposited by Sri Madhav Bia was in the school account. In the meantime, another grant of rupees 8 lakh for upgradation of the playground of the school received by the school. It is reported by Sri Mukti Das that he spent the entire amount for development of the school playground. On inspection of the school, it is observed that the said amount of rupees 9 lakh, 1 lakh plus 8 lakh. Sri Mukti Das spent the amount for construction of old boundary wall, approx 1200 feet long and 2.5 feet high, in height. Art filling the school playground, constructed a partition wall, approx 250 feet long and 5 feet in height, and repairing of goal post of the playground. But Sri Mukti Das could not produce the vouchers, bills, etc. at the time of inquiry, even till date. Although the cash book maintained for the purpose is also not furnished during the course of inquiry. Further, Sri Mukti Das damaged a large number of valuable trees, sagun, for development of playground. But it is seen that Sri Mukti Das neither obtained permission from the concerned forest department nor approval of the SMBC for this purpose. However, Sri Mukti Das reported that he has made some furniture for the school from the timber of the damaged trees. In the meanwhile, Sri Mukti Das submitted a representation dated 11/2/2020 seeking some time for submission of bills vouchers regarding expenditure of rupees 9 lakh and requested the authorities to provide him copy of the allegation raised against him. Thus, the inquiry report is submitted before the Honorable Director of Secondary Education Assam for kind perusal and for further necessary action. So the findings lordship give the petitioner a clean sheet, and whereas lordship he could not produce any vouchers and he has cut second trees illegal without any permission lordship. In terms of the inquiry report, lordship, you can see another order at page 63. Lord. Page type copy is lordship page 60. Status report in connection with selection of regular principal of Vaidyanga High Secondary School. In inviting a reference to the subject stated above, I have the honor to submit a status report in connection with selection of regular principal. It may be mentioned here that Sri Mukti Das was appointed as regular principal of Vaidyanga High Secondary School under Nagaon district by his office order number 2017 in compliance of the Honorable High Court order dated 28/8/18 passed in WPC 2638 of 17. The appointment order of dated 2/5/2017 in respect of Sri Mukti Das was set aside and passed by this office order dated 26/2019. Referred to the matter to the State Selection Board for reconsideration of selection of regular principal in between Madhav Bia and Mukti Das as per Honorable High Court order, particularly to pay attention with the provision of the Rule 12 and 13 of the Assam Secondary Education Provincialized Service Rules of 2003 as amended. However, in pursuance of the government letter dated so and so, the departmental proceeding has been drawn up against Sri Madhav Bia, assistant teacher of the aforesaid school under Nagaon district by this office order dated 2/7/2021, and subsequently the departmental proceeding has already been dropped as the allegation against Sri Madhav Bia has not been sustained by this office order dated 2/7/2021. Consequent upon the departmental proceeding has been initiated against Sri Mukti Das of Vaidyangi High Secondary School under Nagaon district based on the findings of the inquiry report submitted by a group of officers, wherein few serious allegations has been leveled against Sri Mukti Das. Accordingly, departmental proceeding has been initiated by issuing show-cause notice to Sri Mukti Das, assistant teacher, by this office notice dated 29/6/2021. In view of the above facts, government is requested kindly to look into the matter and accord necessary approval for appointment of regular principal of Vaidyangi High Secondary School under Nagaon district on the recommendation of the State Selection Board. So in the review selection lordship, the petitioner stood first, and the director had passed this order lordship, seeking approval from the government to appoint the petitioner. In terms of that, now in view of the retapil order lordship, now that observation is very much there lordship, that since the inspector of school is holding the search at present, so he will continue till the decision in the writ petition to be heard afresh by the learned single judge. That was the finding of the in the division bench. So despite the division bench order lordship, only because of a legal opinion obtained by the government lordship, the order has been passed at page 71 lordship.
Where is that?
Page 71, annexure 70.
No. The observation of the division bench that
Yes.
it is
That
the inspector of schools is holding the.
it is submitted at the bar at page 69 also. That was agreed between all the parties also. That is only agreement also. It is submitted at the bar that at present the inspector of schools is holding the charge of the principal of the school in question, and therefore there is urgency in the matter. Since urgency has been expressed by both the sides, requesting for an early hearing and disposal of the writ petition. We direct the registry to list the writ petition being WPC 2638 of 2017 before the learned single judge as per the roster on 17/6/2022 for orders. In the meantime, the parties may extend pleading. And in the meantime, Lordship, the respondent member Mukti Das has also filed affidavit in opposition, and we have also filed affidavit in reply. That is before your Lordship, which is connected as item number 13. So the division bench order is very much clear. Also, the inspector of school will continue to hold the charge of in charge principal till the decision in the writ petition also to be heard afresh by the learned single judge. Now a legal opinion has been obtained, and in view of the legal opinion also, the government has passed this interim order at page 71, 25/11/2022.
Yes, so is in the secondary.
My lord.
Yes, Mr. Majumdar.
The order of the single bench, the division bench, does not bar us from, it does not restrain us in any manner from allowing a certain person to hold the principal, my lord. The writ petition being remanded back, the original order not being interfered with till now, the original selection would stand, my lord. Here, what I find is at page 40, can we have page 43? I'm sorry, no, page 45. Page 45. An internal communication, my lord, to the council. Copy not marked to the petition. Nothing to say how this communication came to his hand. Page 46, another page 48. Again, another internal communication to the council. These are privileged communications. They come on record. So it's not divulged.
Two things are there. In writ petition, that's why we have called for the records. In WPC number 2638/2017. Initially, when the present petitioner challenged the appointment of the private respondent, it was the court on May 5th, 2017. Passed an order when the specific prayer for interim direction was made. The court passed an order saying that appointment of the respondent number 7 will be subject to the result of the case. And also as an observed that it will be disposed of with the writ petition stage of motion itself. So returnable date. Matter was disposed of on 28th of August 2018. And thereafter, pursuant to that single judge's order, proceeding took place, whatever, that we are not. Now, the division bench set aside the order of 26th of August 2018 and did not, while setting aside, did not observe status quo ante, because once that final order goes automatically back to that stage. But here, both the parties say that presently it is managed. It is, the school has been managed by the inspector of school.
Yes.
Had there been a case that since this order has been passed, setting aside the order of the single judge. So it will be status quo ante. So in terms of that, till disposal of that writ petition, even thereafter, it is the private respondent who continued in between. Because whether in the order of 2018 there was any observation that the school has been managed by the inspector of schools?
Yeah. Therefore, some quick decision needs to be taken.
No. In the order.
Yes, that is one. Page 17.
Single bench order.
It is single bench order.
What is the order in the single bench? Whether there is any observation that it is the inspector of schools managing the.
Till such reconsideration and appointment of a regular principal in said Radina High Secondary School. Said access school shall be managed by the inspector of schools, Nagaon, including the power as during and disbursing officer. Page 35.
That's right. That's why we ask you to read it.
My lord.
When the honorable division bench set aside the single bench order, it could have also set aside that part.
My lord, when the order is set aside, it goes
That's
as a
true.
whole.
That
It
is
goes
why
as
you
a
are
whole.
asking. That goes. That is what is the law, right?
So therefore, now, my lord, when the
But
this part of part of the direction
here, thing is, both the parties have said that it is now managed.
Yes, managed.
Right?
Yes.
So the court did not interfere. The division bench did not interfere with that part of the observation. Since there is a specific direction from the court.
This is not from the observation. This is not from the observation of the honorable court, my lord. Honorable single judge, my lord. This is because the
Till
party
such
say it
decision,
is being-
that is the reason.
Therefore, it was.
That is why.
Therefore, division bench did not go into that part of the order. The entire order has been
That
set
is
aside.
your version of submission.
So
That
what
is
lordship's
your version of
interim order
submission.
was already there.
See,
saying that it will be only subject to outcome the repetition. It only remains subject to outcome the repetition.
now that
So
order
therefore, the
goes.
person who was selected or appointed,
Right.
that is only subject to outcome the repetition. It is neither under stay nor being set aside. Why should you not have the?
Anything?
That is what I was trying to.
Fine. Yes, Mr. Mahanta.
Lord, what has fallen from your lordship? First, let me attend to it. The learned division bench has set aside the order of the learned single judge. So, by virtue of that division bench judgment, whatever was observed, whatever was held, whatever finding was recorded, everything has gone. And now the whole matter is open for reconsideration. Matter was remanded. Therefore, in my full submission, it starts from the very fresh beginning when first notice was issued without any interim order. My understanding of the order of the learned division bench is that it reopens now, it falls open from the very beginning. The whole matter can be heard and decided now. Therefore, earlier interim order, if there was any, that goes. And notwithstanding the observation of this honorable court that the inspector of school will manage meanwhile, that has also gone because the entire judgmental order has been set aside. Having said so, now the question comes when the parties have agreed that yes, the inspector of school is running the school, whether that will in any way cast an embargo on the power of the government or the authority who has retained the power to allow him to continue to work. In my full submission, it will not. Because what we apprehended that time, that till that day, the inspector of school is discharging the duties of the principal, which is not to the benefit of the school as such. Therefore, there is an urgency to hear the whole matter early. Because we did not know what the government is anticipating, what the government will do. Notwithstanding the pendency of this writ petition, although the matter has been remanded back. Therefore, there was an urgency expressed by both the sides that it may be heard early. And accordingly, we took our steps. Matter has not been heard till today. Meanwhile, the government thought it fit that it would be proper for the good of the institution, for the students, because since 1996, Lord Chief will kindly see, there is no regular principal here in the school. The school is suffering. In 2017, when I was first appointed as the principal, I could work only for 2 years and 2 months. And thereafter, the litigation started, and I was then dropped. Then another person came in, the petitioner came in, then again he has gone. Now the inspector of school is taking over and running the affairs. That being the situation, when the division benches set aside the order of this honorable court, then what is the position? The initial order of my appointment, which is a regular order of regular appointment to the post of principal, that is surviving as on today, it is in force. And you see, 17 order.
That we have seen.
Yes, that was the initial order of appointment. That was done in a regular manner on the basis of the selection made by the selection committee. The authority appointed me regularly. That is the order as on today standing on record. And there is no embargo from any court, from any authority, that you cannot implement that order. Therefore, government has every right to decide that, because in the interest of the school, let a regular principal work, and that will be followed by the further order. If it comes from this honorable court, it will take care of itself. There is no requirement to do anything more. But as on today, what is the option left to the government? Authority is to act upon the surviving order, which is a valid order as on today, holding the field. That has to be given effect to. And that is what has been precisely done here. Kindly see, the impugn order here in this petition, page 71, Lordship will come in first. What the order has said. This is the order from the Secretary to the Government of Assam. At page 71, I will read it, my lord. 25th November 2022. Order read. The order of the Honorable Guwahati High Court dated 3/6/2022, passed in writ appeal number so-and-so, so-and-so and so-and-so, and WPC number so-and-so, so-and-so, that is petitioner's earlier case, contempt case number so-and-so, and subsequent contempt case number so-and-so. Also read the petition dated so-and-so and so-and-so, submitted by the petitioner Sri Mukti Das, Assistant Teacher, Raidungia High Holiram Soikia Higher Secondary School under Nagaon District. Findings. Sri Mukti Das was appointed as principal on regular basis and posted in Raidungia Holiram Soikia Higher Secondary School under Nagaon District, video order number so-and-so, dated 2/5/17. This was my original order of appointment. Challenging the order dated 2/5/17, Sri Madhav Bhuya, who was the candidate for the same post and recommended serial number 2 by School Selection Committee, filed a High Court case being WBC 2638/2017. And the Honorable High Court has passed an order dated 28/8/2018, by which the appointment order 2/5/2022 was set aside. That should have been 2/5/17 was set aside, and quashed video order number so-and-so dated 26/2019, and referred to the matter to the State Selection Board for reconsideration of selection of regular principal in between Madhav Bhuya and Mukti Das, as per Honorable High Court order, particularly to pay attention with the provisions of Rule 12 and 13 of the Assam Secondary Education Provincialized Service Rule 2013 as amended. Being agreed, Sri Mukti Das appealed to the Honorable Guwahati High Court video WA 201 of 2020, where the Honorable Court has directed video order dated 3/6/2022 set aside the impugned judgment and order dated 28/8/2018 and remanded the writ petition to be heard by the learned single judge afresh on merit. In this regard, views of Advocate General Assam has been obtained, and he opined that there is no legal impediment in allowing Sri Muktidas to act as principal of Raidinga Holyam Soike Higher Secondary School. Approval of the authorities obtained on the views of the Advocate General Assam. Order, after careful consideration of the above and approval of competent authority obtained accordingly, it is decided that Sri Muktidas may be re-notified as principal Raidinga Holyam Soike Higher Secondary School, Nagaon. It is not a reappointment, it is only re-notified. Appointment order dated 17. And then page 73, Lordship will see. This is 13/1/2023. This is by the director. Whereas Sri Muktidas, assistant teacher, Raidinga Holyam Soike Higher Secondary School, Nagaon district, was appointed as the ruler principal of Raidinga Holyam Soike Higher Secondary School under Nagaon district, with this office number so and so, dated 2/5/17. Whereas in compliance of the Honorable High Court's order dated 28/18, passed in WPC number so and so, Padobhian, State of Assam, the appointment of the Muktidas as regular principal of Raidinga Higher Secondary School, Nagaon, was issued with this office order number so and so, dated 2/5/17, was set aside with this office another order number so and so, dated 26/2019. Now, in pursuance of the government order number so and so, dated 15/25/11/2022, and in compliance of the Honorable High Court's order dated 3/6/2022, passed in writ appeal number 201 of 2020, Muktidas versus the State of Assam. Sri Muktidas hereby re-notified as a regular principal of Raidinga Holyam Soike Higher Secondary School, District, Nagaon. Accordingly, the Inspector of School NDC, Nagaon, who is now holding the charge of the principal, is hereby relieved from the charge of principal of Raidinga Holyam Soike Higher Secondary School, Nagaon. So, this order is not an independent order. This is an order only re-notifying the order of appointment issued in 2017. As I submitted already, as on date, there is no hurdle against this order, and therefore authority has a right to implement it, and authority has, in my response submission, very rightly allowed, or by re-notifying this and asking the Inspector of Schools to get relief and hand over the charge to me. And I have taken over. On
Mr. S.K. Das, Council Affairs for the petition.
17/1.
May I make one submission? Responding to what my senior said. My lord would see here, the order was set aside, no doubt about it. But after setting aside the order, my lord, there is an observation. And the observation is that the inspector is holding the field. Both parties will now go before the Honorable Single Judge and hear it. And this is a prayer, not emanating from the court, but from the bar. All the people, all the participating councils had made this prayer. Now, what had happened, my lord, in the meantime? I'm not going as to the effect of the order. In the meantime, my lord, there is a development. The development is that he is being subjected to a departmental proceeding. That departmental proceeding is pending till date. And that occasion before the order of re-notification. Re-notification, my lord, tantamount. It's not, my lord, that the earlier order will continue. They have not said that. They said the order is re-notified. That means it's coming in a new form. If it is coming in a new form, my lord, if there is a departmental proceeding pending, that order could not have been issued. That's my second line link of argument in the case. My lord would find the department proceeding particulars in page 61. 61, my lord, last two paragraphs. There was a department. What had happened here was, my lord, the state selection committee recommended my name. The government said, hold the proceeding against me. Inquiry was done. I was exonerated. Last two paragraphs of page 61. Consequent upon the department proceedings has been initiated against Muktidas of Raidinga HS Saika High Secondary School under Nagaon district based on the finding of the inquiry report submitted by a group of officers wherein few serious allegations has been leveled against Sri Muktidas. Accordingly, departmental proceeding has been initiated by issuing show cause notice to so-and-so Why this office notice number so and so dated 29/6/21? Now, while passing this order by the government and even my lord taking the view of the Advocate General, these facts in all probability were not brought to notice. If these were brought to the notice, this order could not have been passed. My lord will only require the Departmental Council to place that fact before your lordship, before my lord takes a decision in the matter. This is my humble submission, madam.
Lord, I have a reply to this. Let us assume the worst situation as on today, that there is a departmental proceeding pending against me. Let us assume it. What my learned friend has submitted is correct. What will be its legal implication on my appointment, which was made in 2017? I was regularly appointed in 2017. Let us take it that thereafter, in 2021 or 2022, a departmental proceeding is initiated against me. Can that departmental proceeding by itself will be sufficient to bring me down or to deprive me from the post of regular principal? No. They will have to take the departmental proceeding into a logical end. If thereafter they find that I am liable to be impose certain penalties, they may impose any penalty they like. But that by itself cannot be a ground to deny me the post of my office, which was appointed in 2017, because I was appointed in 2017. The departmental proceeding by learned friend is pointing out is subsequent thereto. And I will show to your lordship. Lordship will be pleased to find I have all these documents with me. I will place it. It will appear that the director that time did not act fairly, and therefore the government has to take up. And government has said that allegations which were made against me were all false. There is no substance. This letter was written by the Principal Secretary, Education Department to the Director on 23rd July 2020. I have these copies also. I will place
July
it on
20,
record.
but the proceeding started in 21. Madam.
Therefore, my learned friend has already made his point, and his learned junior made that point earlier before his arrival. So he is repeating it only. So let me reply to it. So lordship will find that as on today, the departmental proceeding I replied, and the government found it fit not to act upon it. They are sitting silent. No inquiry has been initiated, nothing. So cause was issued, I have given a reply, and the matter rested at this. So that by itself cannot be a ground to say that my order of appointment dated 22/5/2017 cannot be given effect to. That cannot be. That will not.
Based on
Therefore, my lord, there is no prima facie case, no question of state.
February. Enabling the respondents in the secondary education department of the state to place the following records in original. One. File number AAC.486/2017/PT. Wherein the order number same like PT episode 182 dated 25/11/2022 was issued by the state government, was issued by the Secretary Government of Assam in the Department of School Education. 2. Number GB-CST/DISP D capital /1/2020/361 dated 13/01/2020. Sorry, wherein 361 illegal, wherein the Director of Secondary Education Assam passed the order number, passed the order link into nil. Same like 2020 later, that was 361 dated 13/01/2023. Petitioner shall furnish 2 extra copies of this report to Mr. Mazumdar attending conference during the Armada course of the day. I need a copy of this order, Mr. Mud.
We'll do it tomorrow.
Mr. Mudanda, take this order today. It'll come up on second.
On some other day, second, second time will be here. Third,
sixth.
Malad is having it on 6th.
Right.
Fourteen.
Yes.
Please, Lordship. My lord, in this petition, we have challenged is 28. Order for the respondent number 4, Lordship. What even, Lordship, in this case, my lord, petitioner was appointed as headmaster in a Venture LP school in the year 1995, Lordship. His school was provincialized in the year 2013, Lordship. Until date, he is continuing as headmaster, Lordship. My lord, the respondent number 6, who was a teacher of nearby school, and his post was provincialized as tutor in the year 2021, Lordship. And after provincialization, there was a direction from the respondent number 4 to utilize his service in the petitioner's school, Lordship. My lord, now the respondent number 6, who is a tutor and much junior to me, is appointed as headmaster of the school, Lordship. Lordship, may kindly see the provincialization order at page 14. Page 14 and 17. Here, I have been shown as the headmaster of the school in question, Lordship.
Where is the merger order?
Lordship, that you lordship will find at page 21, lordship.
Where is the order?
That speaks, that specific order is not there, but it reflects from the order passed by the.
There it will be there, who will be the head teacher. Where is the merger?
That specific order is not there, lordship, but you lordship will find from page 21. This is the order passed by the respondent number 4. That is the DO, lordship. First paragraph. Lordship.
Yes, who is appearing? Tell us.
They have not announced the merger order.
Now, two 2017 Act also provides any teacher serving in a recognized LPME secondary school structure to serve in other school. What all these days we have seen that a school is teaching staff of a particular school or provincial. 1, 2, 3, 4. Some may be teachers, some may be tutors. And that particular school that has been provincialized, they will be merged with particular school, or the person concerned will be made a tutor, will be allowed to serve in other school. Now in that circumstances, tell us, here what we have seen, that the respondent number 6, please come to page number 19. Here the school has not been, kindly read page number 19. You will see this school has not been provincialized.
The post has been provincial.
Which school has been provincial?
But the post of the.
Can it be done?
Yes, ma'am.
2017 Act provides that.
Yes.
Which provision? Which provision allows that? Yes, which provision?
Is only after some time. Matter may be taken after some time.
Very good, actually. Yes, Mr. Fukan,
Milord,
tell us.
Milord, I take your lordship straight to annexure A of my IA, Milord.
My lord, should I place my case? My lord? Otherwise, come back.
Milord, page 15, Milord.
Page 15 of what?
Internal page 15, Milord, interlocutory application. 3610-2022.
The
9075-2019, the first case, Milord.
which you have filed today.
No, Milord. The affidavit in reply has been filed today. The original IA, Milord. I am referring the original IA. IA number 3610 of 2020.
You have filed application where? In the IA?
IA in 9075 of 2019.
Sharma, I think you have clear it. Yes.
There is only one IA, Milord. Page 15, annexure A.
Of petitioner.
No, Milord. Interlocutory application.
That's why we're in the interlocutory application.
Page 15.
Who's by the university or who?
By the university.
When it was filed?
It was filed on 24. It was filed on 24/8/2022.
Objection?
No, Milord. Objection was filed same day, Milord.
You preferred the IA, right?
Yes, Milord. The affidavit in opposition to 9075 of 2019.
That's
as well
different.
as
Your
IA.
application you are talking about.
Milord.
You are talking about your application.
Yes,
IA.
Milord. IA.
Page 15.
Page 15.
Yes.
Milord, this is the result of the first round of inquiry, Milord. As per his version, Milord, he has been given clean sheet on 15/11/2018 by the issued by the Registrar of Guwahati University. Page 15. The last two lines, Milord. Hence, the university hereby declares the matter settled, and no further complaint on the matter will be entertained. This is issued with the approval of the Honorable Vice Chancellor of Guwahati University, dated 15/11/2018. Same day, this letter has been issued to Nadim Akhtar with a copy to Professor Rakibuddin Ahmed, the petitioner in the instant matter. Now, kindly turn to next page, Milord. The regulation, UGC regulation. It was promulgated on 23rd July, and the Gazette notification is on 31/7/2018. Milord, kindly come to clause 11, Milord. Institutional Academic Integrity Panel. IAIP. ACI, Higher Education Institute, shall notify a IAIP whose composition shall be as given below: chairman, member. The chairman of DAIP, that is Departmental Academic Integrity Panel, under it, and IAIP shall not be the same. The tenure of the committee members, including chairman, shall be 3 years. The quorum for the meeting shall be 3 out of 4 members, including chairman. Now, sub clause 2, the IAIP shall consider the recommendation of DAIP. 3. The IAIP shall also investigate cases of plagiarism as per the provisions mentioned in these regulations. Next page, page 21. 4. The IAIP shall follow the principles of natural justice while deciding about the allegation of plagiarism against the student, faculty, researcher, and staff of ACI. 5. The IAIP shall have the power to review the recommendations of DAIP, including penalties, with due justification. 6. The IAIP shall send the report after investigation and the recommendation on penalties to be imposed to the head of the ACI within a period of 45 days from the date of receipt of recommendation of DAIP or complaint or initiation of the proceedings. 7. The IAIP shall provide a copy of the report to the person against whom inquiry report is submitted. Now the penalties, Miller, clause 12. We can skip 12.1, note 1, note 2, 12.2. Penalties in case of plagiarism in academic and research publications. 1. Level 0, similarities up to 10%. Minor similarities, no penalty. 2. Level 1, similarities above 10% to 40% shall be asked to withdraw manuscript. 3. Level 2, similarities above 40% to 60% shall be asked to withdraw manuscript, shall be denied a right to 1 annual increment. 3. Shall not be allowed to be a supervisor to any new master's, MPhil, PhD student scholar for a period of 2 years. Now 4. It is relevant, Miller. Since plagiarism is above 63%, Miller, now level 3, similarities above 60%. 1. Shall be asked to withdraw manuscript. 2. Shall be denied a right to 2 successive annual increments. 3. Shall not be allowed to be a supervisor to any new master's, MPhil, PhD student or scholar for a period of 3 years. Now, note 1, we can skip, Miller. Note 2. Since he is the head of the Department of Persian Department, penalty in case where the benefit or credit has already been obtained. If plagiarism is proved on a date later than the date of benefit or credit obtained, as the case may be, then his or her benefit or credit shall be put in abeyance for a period recommended by IAIP and approved by the head of the institution. This is IAIP proceedings under UGC regulation. This has been, Miller, adopted by the Guwahati University, and it was July 2018, and on 25 January 2019, the first IAIP was constituted through a notification as issued by the Academic Register of Guwahati University after near about 6 months. Now, kindly turn to next page, Miller. The letter was issued on 23/11/2019. In the meantime, Miller, that Chancellor's inquiry report has been received by the university authority. So, Miller, the first route, Miller, regarding this IAIP route under UGC regulation, it has been adopted. A so-called notice has been given, Miller, on 23/11/2019. May I read, Miller? It is important. To Professor Rakibuddin Ahmed. Sir, as directed, I am sending a copy of the report received from the experts as appointed from the office of the Honorable Governor of Assam regarding the allegation of plagiarism in your PhD thesis. The IAIP, Institutional Academic Integrity Panel Committee, Guwahati University suggests that your reply is to be sought on the report from your side before a final decision is taken. You are expected to give a point-by-point rebuttal clarification, if any, to the points raised in the report within 10 days from receipt of this letter. Your written reply may be submitted to the undersigned. Copy to the chairman IAIP. It was issued by the Academic Register. Miller, it was issued on 23/11/2019. Now, if your lordship turn to the reply filed today, Miller. Page 81 to 83. Reply filed today, Miller. Page 81 to 83.
Yes.
Annexure 3. That notice was issued on 23 November 2019, and he requested the university authority within 1 week on 30/11/2019. May I read, Miller? Page 81. To the academic register, sir, which refers to the subject matter cited above. I have the honor to inform you that I have been suffering from spinal problems since last week and also busy with some urgent examination related work for which I cannot complete my comments on the report within the 10 days given by you. I therefore benignly request you to kindly give me 1 week more time with effect from 02/12/2019 for submitting my comments on the report received from the office of the Honorable Governor of Assam regarding the allegation of plagiarism in my PhD thesis. This is for your kind consideration and necessary action. Now, my lord, I take your lordship to page 69, my lord. It will be very important, my lord, very relevant to the instant proceeding, my lord. Page 69, paragraph 4. That with regard to the statements made in paragraph number so and so, while putting the respondent number 1 to the strict rule thereof and reiterating the statements made in the interlocutory application, it is humbly stated by this deponent that the double jeopardy aspect, as envisages under Article 22 of 20, Milord, Article 2 of the Constitution of India, cannot be brought into the instant matter in view of the fact, next page, Milord, page 70, that it does not cover any departmental proceedings which is not held before a criminal court. I have the authority, Milord, the 5 judges constitutional bench in S.B. Swan, as well as Mokbul Hussain, Milord. Further, the letter dated 23/11/2019, as issued by the Academic Register of Guwahati University, was a request for comments on the report to the said respondent number 1, in compliance of the directions of superior authority, in tune with the provisions of the Constitution of India and the laws framed thereunder, including the UGC promotion of so-and-so, Regulation 2018, as well as the Guwahati University Act 1947 and the rules framed thereunder. It would be relevant to state here that the Honorable Apex Court has on several occasions clearly held that it is unjustified in invoking the extraordinary jurisdiction of High Court under Article 226 of the Constitution of India without first showing cause against the so-called notice before the competent authority. The Honorable Apex Court has also strongly deprecated, even imposing costs, the conduct of the party who, after taking extension of time for the purpose of filing so cause, instead moves the High Court under the said Article 226. In this context, it may be pointed out here that the writ petitioner respondent number 1 has intentionally suppressed the material fact that he submitted a request letter dated 30/11/2019 as addressed to the Academic Register of Guwahati University, stating inter alia that as he was suffering from spinal problems since last week and also busy with some urgent examination related work, he could not complete the comments of the report within 10 days given by the said academic register, and as such he requested to give 1 week more time with effect from 2/12/2019 for submitting his comments on the report regarding plagiarism in his PhD thesis, enclosing copies of the prescription of the doctor as well as the appointment letter of the examination related work. It is stated that afterwards, in view of this request letter, the writ petitioner respondent number 1 was given extension accordingly, and surprisingly, within the said extended period, he filed the aforementioned writ petition bearing WPC number 9075/2019 on 4/12/2019, obtaining the interim order of stay dated 6/12/2019 from this honorable court, suppressing and not making any whisper about the said request letter and or said extension period granted by the university for the crystal clear purpose of replying or commenting on the report regarding plagiarism as contained in the university's impugned letter dated 23/11/2019. It is stated that recently the writ petitioner respondent number 1 has been suspended pending drawal of departmental proceedings against him by a communication of the university dated 17/11/2022. And it would be relevant to state here that statutory appellate provision is also there, which could be resorted to by an aggrieved party. Further, it is vehemently denied by this humble deponent that the approach of the applicant university is not at all clean, as alleged in the aforesaid affidavit in opposition objection, particularly on the purported ground that the matter is sub judice before this honorable court, and the applicant university started parallel proceeding in the matter. Rather, this deponent humbly begs to point out here that with a well thought out strategy, the writ petitioner respondent number 1, taking the benefit of extended time granted by the university authority, has converted, it is important, my lord, has converted an exercise statutorily entrusted to the academic experts into a judicial exercise, taking the plea of the so-called double jeopardy aspect, purposefully as well as craftily avoiding a point-by-point rebuttal clarification, if any, to the points raised in the report as per the aforementioned request letter of the university dated 23/11/2019. Otherwise, he would have raised all the pleas as contended in his instant writ petition, along with point-by-point rebuttal clarification before the university authorities concerned in this regard, refuting such a heinous and despicable level of academic corruption on his part. From his such conduct, it is abundantly clear that the writ petitioner respondent number 1 is not at all clean while seeking relief from this honorable court. On the other hand, the writ petitioner respondent number 1, after getting the purported clean sheet dated 15/11/2018, immediately lodged an FIR dated 23/11/2018 at Jalukbari Police Station, annexed as Annexer 18 to his aforesaid writ petition against respondent number 9, Nadim Akhtar, investigation of which is still going on. And it is another parallel proceeding started by the writ petitioner respondent number 1 himself, arising out of the very same subject matter, without any intimation to the police station concerned so far regarding the matter having been sub judice before this honorable court since 2019 with interim order in the said matter. It may be humbly stated that the honorable apex court on numerous occasions held that in identical facts as well as charges, the departmental proceedings and even the criminal proceedings can go on simultaneously. Whereas in the criminal proceedings, the standard of proof is more stringent with the application of the doctrine of proof beyond doubt, while it is not applicable in case of departmental proceedings. Further, the interim order as passed in the aforesaid WPC number 9075/2019 as regards the letter dated 23/11/2019 only, and not for any other departmental proceedings. As such, and in view of the instant legal factual matrix, the aforementioned suspension pending drawal of departmental proceedings against the writ petitioner respondent number 1 is legal and lawful and does not amount to any interference with the dispensation of justice as alleged by him in the aforesaid affidavit in opposition objection. Now, if we turn to the Guwahati University Act, section 8, the power of inquiry by the chancellor, the governor. Guwahati University Act, Miller.
How many affidavits you have filed?
Millard in 9075, Millard. Millard, one affidavit in opposition by the university, one by the chancellor's office, and one additional affidavit by the writ petitioner, then affidavit in reply and this IA, and affidavit in opposition to the IA.
Now, when did you file this IA?
I was filed on 24/8/2022.
For what?
Millard, since Millard, that IAIP route has been stayed by this honorable court, that IAIP route under UGC regulation.
Which has been stayed?
Millard,
Which court have stayed?
This honorable court, my lord, rendered by Justice N.K. Singh. The order has been annexed, my lord, in the IA, my lord. May I read that order?
Just a minute, just a minute.
44 and 47. I will place the authorities, the constitutional bench judgments later, my lord. First, the provision under University Act. The
Now,
stay order.
by filing an additional affidavit or affidavit reply.
The writ petitioner has filed affidavit in opposition, objection to the IA on 2nd January, my lord. And I have filed today, my lord, reply to that affidavit in opposition to the IA.
Additional affidavit has been filed on behalf of the chancellor on 13 December.
The first case, my lord. The stay order, my lord.
Just a minute, looking for something. Yes.
My lord, the stay order, my lord. In the IA, it has been annexed as Annexure E, page 44 to 47. my lord. In my IA. Annexure E. It starts from page 44 The relevant portion is page 46 and 47. May I read? The last page 46, Miller. The last two paragraphs, Miller. The petitioner is aggrieved by the reopening of an alleged case of plagiarism. Miller, may I read, Miller, the entire order, Miller?
Yes.
6/12/2019, Miller, before Justice N. Koteshwar Singh. Heard Mr. D. Das, learned senior counsel for the petitioner, heard Mr. Swenso, higher education. Mr. B. Deuri, a government advocate, appearing for respondent number 2, Ms. P. Bormon, learning standing counsel, Guwahati University, appearing for respondent 7, and so and so. Issue notice, returnable so and so. No formal steps, petitioner to take step. Now, the last but one para. The petitioner is aggrieved by the reopening of an alleged case of plagiarism lodged against the petitioner earlier, which was closed after due inquiry and verification involving experts. Even though the said complaint had been closed by the impugn order dated 23/11/2019, it is sought to be reopened. Next para. Learned senior counsel for the petitioner submits that it is impossible to do so, as it amounts to double jeopardy. Next page, Miller. Page 47. Accordingly, in the interim till the returnable date, the impugn order dated 23/11/2019 shall remain suspended. It has been, Miller, continued, Miller, by later orders, Miller, in February and in August, Miller. Miller, this order has been passed, Miller, against that show cause notice, Miller. But the Supreme Court is clear, Miller, that no petition under Article 226 lies against a show cause notice. And that aspect, second, that double jeopardy as envisaged under Article 22. Miller, in 2015, Miller, the Supreme Court held, after discussing all the constitutions of UK, Canada, USA, Pakistan, New Zealand, Miller, that double jeopardy as envisaged by the Constitution of India is only regarding criminal proceedings, not civil offense, Miller. It's again criminal offense. I'll place those authorities later. So, Miller, first one, that double jeopardy. Second one, the petition under Article 226 against a show cause notice. And the third one, it is very, Miller, relevant, Miller, to the instant matter, Miller, the conduct of the petitioner, Miller. So, Miller, if we skip other things,
Mr. Fukan,
there are two routes.
Mr. Fukan,
Miller.
the writ petition has been filed by the petitioner, present writ petition.
Miller.
Challenging the order of suspension. Right?
Second one.
Which is for motion.
Miller.
Which is for motion at the stage of motion.
Miller.
In the earlier writ petition, you have filed a reply affidavit in opposition.
Miller.
Giving the details.
Miller.
Thereafter, you have filed an IA.
Miller.
To set aside this order.
Miller.
Vacate or alter. Those are for in different stage. We are in the stage of the motion against the order of suspension issued against the petition.
Miller.
Morning, you have filed an affidavit saying that there is a misconduct on the part of the petitioner, which you have brought to the notice of the court by filing an affidavit.
Lord,
so it matters to be taken up at 2 o'clock.
It touches upon the misconduct, Lord, but in fact, it is an
now
affidavit in
just
reply.
tell us whether any person feeling aggrieved,
Miller,
that his rights are violated,
Miller,
can he or she can be restrained to approach the court?
No, Miller.
If some person feels
Definitely,
that his certain rights
Miller, under
conferred
Article
upon him
26, Miller,
by the Constitution of India is violated, can he or she can be stopped to approach the court?
Miller, we are pinpointing about the conduct, Miller.
Now, approaching a court saying that, feeling that his rights have been violated,
My lord.
will it amount to a misconduct?
My lord, that will be proved in the departmental proceeding. Charge sheet have not been framed as yet, my lord. My lord, otherwise, I admit, my lord, it will be a legal anarchy, my lord. If my
Then
lord,
in that way,
one is restrained from moving,
there
this
will be no
court,
2026
at
application.
first glance, my lord, I have also thought like this, my lord. But the Supreme Court is clear, my lord, that conduct part strongly deprecated, even imposing cost, my lord. I'll place that authority, my lord, later, my lord.
Now the conduct, first of all, it has to be a conduct.
He took time from the authority.
Then where
that
he will
I
go?
will-
He is aware. He is aware. Once
And
a proceeding
craftily
started
avoided.
on the basis of an application of some complaint, a proceeding started, matter found, he was declared that no plagiarism. Right?
There is
Again,
something- Miller, there is
after that thing,
you
something.
see, if your lordship goes through the chronology of events.
But kindly show us one
But
thing.
since university
In that
has-
report,
University has given that clean sheet.
that discrete inquiry,
Miller.
kindly show us particular statement by the inquiry committee, those two persons, that inquiry, discrete inquiry, that the petitioner has duly recognized the work done by, on the basis of which the petitioner copied those materials. Is there any finding?
Miller,
Show
the
us,
findings
show
are
us,
in the
show us from the record. Is there any finding?
second round of inquiries, Miller. That day the learned.
These are all annexes in the part of the affidavit of the 2019 case, right?
Yes.
Show us from that any finding by that committee.
Miller, your lordship may pick up the.
Whether there is any finding by that particular committee that the petitioner has also recognized the work of that gentleman on the basis of which he had copied from that, his thesis.
Lord, the writ petition as well as the additional affidavit filed by the Chancellor's office, Miller.
That is the report.
Miller.
They have shown this copied. Now
And
kindly
60
show where it has been given recognition.
Lord, that will be academic domain, Miller.
No,
We
show
are
us,
no
because
experts,
we
Miller.
do not know.
That is why
We do
that-
not know.
That is why, Miller, that
We ask you a
IAIP
question.
that
What
IA
is considered to be plagiarism?
It's very relevant, Miller. That is why that IAIP
Now,
proceedings
listen.
should be started, Miller.
In the affidavit,
In
which
that
you have
proceedings,
filed,
Miller, that
in the writ petition, there is an annexer of 2018 regulation,
yes,
2009. You have just now pointed out certain provisions.
Miller. IAIP, Miller, earlier, Miller, 2016 regulation was there, but it
Please
was
come to page number 56
of the writ petition, Miller.
2019 writ petition.
Miller. 56, Miller.
These are, there's a particular provision, rule 7, regulation 7, right?
Miller.
Kindly read.
Regarding formation of IAIP.
No, rule 7.
Miller.
7.
7. Similarity checks for exclusion from plagiarism.
Kindly read.
The similarity checks for plagiarism shall exclude the following. All quoted work reproduced with all necessary permission and or attribution. All references, bibliography, table of content, preface and acknowledgements. All generic terms, laws, standard symbols and standard equations. Note, the research work carried out by the student, faculty, researcher and staff shall be based on original ideas, which shall include abstract, summary, hypothesis, observations, results, conclusions, and recommendations only, and shall not have any similarities. It shall exclude a common knowledge or coincidental terms up to 14 consecutive words.
Right.
Miller.
Now, from the report, just
Miller.
because I was just comparing, that's the reason we're asking you.
Miller.
What we have seen, initially the university forwarded it to two experts,
Milord.
for the experts on that thing, court cannot do anything on that, the decision of that expert. There, they have said something.
Milord.
Now, here in this report, kindly show us where these two experts mentioned that the work of such and such has been duly recognized.
Milord, my respectful submission before Milord, we go through all these pages, Milord, and also the thesis. The thesis are which
We are not on that, right?
Milord,
What
since
we have
it's a-
seen that
It's a forbidden area, Milord.
we are not going to touch that. But thing is this, what difference we have found?
That is why, Milord, that IAIP route, Milord. I am repeatedly, Milord, insisting, Milord. That is why that IAIP route under UGC regulation, comprising the academic experts, it is required, Milord. So that stay order, Milord, the university has prayed through the IA to modify or vacate the stay order, so that the IAIP can proceed with these aspects, Milord.
That was the prayer.
Milord, that is why.
That was the prayer.
So prior to filing a point by point rebuttal, including this aspect, Milord, where from, Milord, that original manuscript and other things,
Now,
Milord,
see,
without venturing in
see,
that,
if you allow the IAIP to proceed, right?
Milord.
Fine. But who has to give that report to the IAIP?
Milord, the IAIP proceed on the
basis of the report of whom?
Reports as, Milord, furnished by the Chancellor's office.
Why? Are they the members?
It is like, Milord, that
No,
preliminary
tell us.
inquiry.
You cannot have half from this and half from that.
No, Milord.
Right? If you have to have everything. If you are saying that 2018 regulation is to be followed,
IAIP
let it be
will
followed
have to
properly.
follow national justice under 2018 regulation. So inquiry reports of first round as well as inquiry reports.
Where is
of
that
second
provision of inquiry report of first round, second round? There has to be one inquiry.
Milord.
Then
that inquiry was held.
Whether the committee constituted by His Law Excellency the Chancellor is under the provisions of the 2018 regulation. Why are you feeling shy?
Milord,
there been an inquiry.
Chancellor has not inquired under UGC regulation 2018.
True. That is why, if you are asking now that order should be vacated, modified, and then IIP should be allowed to prosecute or proceed with, on what basis?
On the basis of those inquiry reports.
Now, those
Two rounds
inquiry
of
reports are
inquiry
not in terms of the 2018 regulation. And the IIP comes only under 2018 regulation.
Milord, it has got retrospective effect, Milord. Since,
That-
Milord, that
is why I'm
clause
telling
12
you,
is-
it has to be have a report from a committee duly constituted under this provision, regulation 8, I think so.
May I
Is not it?
May I
Read
humbly
the
submit,
regulation 8.
Milord? It
Read
is
the
not the
regulation 8.
final stand or final say of the IAIP, Milord. This is
This is not
preliminary
a
in
final.
nature, Milord.
That's right. But tell us.
So that is why, Milord, the writ petitioner has been asked, Milord, to show cause point by point rebuttal, including the double jeopardy
No,
aspect.
that is
including-
why, how can you act on that? When will you be able to act on that?
Milord, when the university authorities in receipt of the Chancellor's inquiry,
Hmm.
two routes open, Milord.
Who is
I'm
supposed
again
to-
insisting, Milord. One, this IAIP.
Hmm.
Second one, the misconduct.
Which
under
misconduct?
Conduct rules.
Which is the misconduct?
That, Milord, charges have not been framed as yet, Milord. That will be framed by the.
No,
Executive
misconduct
Council.
because approaching the court, read court.
No, Milord. No. His misconduct regarding possibly, Milord, since charges have not been framed. So I should
Misconduct
not
on the
open my
basis
mouth,
of
Milord,
what?
at this
Which,
stage.
for what misconduct? What kind of misconduct?
Milord, then, Milord, I will have to go to the authority, Milord, first regarding that misconduct on the part of the petitioner.
What was the letter you have written to asking the petitioner to reply point by point?
Point by point. Without, Milord,
Right.
resorting to,
Fine.
my lord,
He took time
my lord,
on medical ground
my lord,
and approached this court.
my lord.
That's misconduct.
My lord, as per apex court, my lord, it is
No,
misconduct.
where is the question of so-called notice?
That
You read
is-
that judgment.
So, my lord,
That was in
I-
a disciplinary proceeding when so-called was issued.
my lord,
That's
that
the
aspect-
judgment you have said, right? That is the 5 judges bench judgment.
No, my lord. That was as this one, my lord, another judgment, my lord. May I place, my lord? Otherwise, my lord,
Thing
I
is
am
this,
not so.
so when
my
the
lord,
that is, don't, if you are saying that yes, it is the IAIP who will prosecute or who will look into it, then has to be follow-up compliance of the 2018 regulation.
my lord,
Because the report submitted is not by the DAIP.
yes,
It is a report submitted by, in a discrete inquiry conducted by His Chancellor, His Excellency. So it is not a report under the DIP. It's not a report under the provisions of Regulation 10
no, my
of
lord.
2018 regulation.
Yes, my lord.
So why, how IIP will act?
My lord, IIP has not been restrained, my lord. They are another authority, my lord.
Which,
If the chancellor or IIP is not restrained, then they can act upon the inquiry report, my lord.
now tell
And
us one thing,
particularly
that is
the
the
chancellor's
reason.
office,
Here is the main two disputes.
my lord,
One committee said no, there is no plagiarism.
my lord.
Another committee said yes, plagiarism. Who will decide?
IIP, my lord,
On what basis?
under
That means there has to be a thorough inquiry.
my lord,
Neither the report of the first committee nor the report of the second committee has to be considered.
my lord.
Initiated fresh proceeding under the 2018 regulation. Who bars you?
That is why that show cause
Then
notice,
tell
my
us in writing that you are going to follow the 2018 regulation in total.
Sure.
We'll immediately vacate this order.
lord. We will follow, my lord.
Neither the report of the first committee nor the report of the second committee.
No, my lord.
You will not able to take any action in the report of either of this committee.
It is in the sphere of preliminary inquiry, my lord. It is not, my lord, final inquiry, my lord. This final stand will be taken by the IIP, comprising all the academic experts.
Not only IIP. There has to be a
Thereafter,
report first by
Vice
whom?
Chancellor.
A report has to be report has to be given to the IIP by whom?
My lord, normally DAIP to IIP. But
So-
since, my lord, it is straight from the chancellor's office.
It cannot be accepted. The committee has to be in person of this.
But the IIP has not been restrained, my lord.
Read provisions.
Yes, my lord. Your lordship has just, my lord,
Yes, yes, rule
indicated
11, rule 11.
clause 7. Now,
Read
kindly-
11.
before that, my lord, may I read, my lord, clause 9.
Hmm.
So motu notice.
Hmm.
Clause 9, my lord, it is
Yes,
important. Detection, reporting, handling of plagiarism.
Hmm.
If any member of the academic community suspects with appropriate proof that a case of plagiarism has happened in any document, he or she shall report it to the Departmental Academic Integrity Panel. Upon receipt of such a complaint or allegation, the DAIP shall investigate the matter and submits its recommendations to the Institutional Academic Integrity Panel IAIP of the ACI. Now it is important. Next, the authorities of ACI can also take suo motu notice of an act of plagiarism and initiate proceedings under these regulations. Similarly, proceedings can also be initiated by the ACI on the basis of findings of an examiner. All such cases will be investigated by the IAI. So, my lord, the first round of inquiry reports, second round of inquiry reports, now it is turned to means, my lord, this IIP will investigate into the matter on the basis of those 2 rounds of inquiry reports. It is now their turn, IIP's turn, to investigate in the matter.
So was that the IIP has so much to have taken the proceeding.
The show cause notice, my lord.
It was on the basis of the report given by the committee constituted by His Excellency the Chancellor.
my lord.
So,
So, my lord, it is a so cause notice, a request letter, just to give an opportunity to the writ petitioner to give point by point rebuttal clarification to the inquiry report.
why?
It's a,
Why the petitioner should give first?
in tune with the
Because
principles
on
of
the
natural
report of that
justice.
committee,
My lord,
on the basis of the report of that committee.
my lord.
But
The
read 11.
principles of natural justice will have to be maintained, my lord. This clause 11 is clear, my lord.
Please come to clause 11.
Clause 11, subclause 4, my lord.
Please come read the entire 11.
My lord. Institutional Academic Integrity Panel. 1. ACI shall notify IAIP whose composition shall be as given below. Chairman, Prof. VC, Dean, Senior Academician of the ACI. B. Members, Senior Academician other than Chairman to be nominated by the head of ACI. C. Member. One member nominated by the head of ACI from outside the ACI. D. Member. A person well versed with anti-plagiarism tools to be nominated by the head of the ACI. The chairman of the DAIP and IAIP shall not be the same. The tenure of the committee members, including chairman, shall be 3 years. The quorum for the meeting shall be 3 out of 4 members, including chairman. 2. Subclause 2. The IAIP shall consider the recommendations of DAIP. 3. The IAIP shall also investigate cases of plagiarism as per the provisions mentioned in these regulations. 3. Next page, Miller. The IAIP shall follow the principles of natural justice while deciding about the allegation of plagiarism against the student, faculty, researcher, and staff of ACI. 5. The IAIP shall have the power to review the recommendations of DAIP, including penalties with due justification. 6. The IAIP shall send a report after investigation and the recommendation on penalties to be imposed to the head of the ACI within a period of 45 days from the date of receipt of recommendation of DAIP or complaint or initiation of the proceedings.
So tell us, when did you investigate?
Milord,
as an IIP, without first there being an investigation by a particular committee under this 2018 regulation on the basis of a report given by 2 other persons. Can you consider it as a report under the 2018 regulation?
Milord,
because it is not the report or investigation made by the IIP.
It is the first
There
step,
is a
Milord,
suo motu power on the part of the IIP because the regulation provides. But where is that investigation made by the IIP? Tell us.
That has not been, Milord, started as yet. It is first step, Milord, that's so cause.
Because on what basis? Why that so cause?
So cause is required.
First of all, only after coming into the conclusion from the IIP or from the report from the DAIP that there is a plagiarism, then you will ask, then you will issue so cause.
It will be.
But where is that? Forget DAIP. You have the power to take suo motu action. But there has to be an investigation by the IIP. Where is that investigation?
Milord, it will be started after
First you will issue so cause, then you will investigate.
Milord, it is not exactly so cause, it's a request.
You are asking for a giving the point-to-point basis. On what basis? The report given by a committee constituted by His Excellency the Chancellor.
Milord, that clause 11 will be read with the clause 9, Milord. That suo motu notice, Milord.
Suo motu notice.
So they have taken suo motu notice of the second round of inquiries, Milord.
By whom?
The IIP, Milord.
Read it again.
Milord, since Milord, it is first, Milord, the authority, Milord. Authority of ACI. They have, Milord, provided those reports to the IIP. May I read again, Milord? That
read it. It is very much clear. Subpara 9.
The authorities of ACI. Authorities means, Milord, Vice Chancellor, Registrar, Academic Registrar also, Milord. Authorities of ACI can also take suo motu notice of an act of plagiarism. So this is a suo motu notice, Milord.
On what basis? Come, then read.
On
the basis.
And initiate proceedings. First, suo motu notice, then initiate proceedings. That proceedings of investigation has not been started as yet, Milord. It's a request letter, point by point rebuttal.
Who are the members here?
The chairman is the pro VC dean senior academician of the ACI. Second, senior academician other than chairman to be nominated by the head of ACI. And third one member nominated by the head of the ACI from outside the ACI.
Where is
fourth
that
one,
finding of the IIP to initiate suo motu proceeding?
Milord,
Had the IIP appointed the examiner?
no, Milord.
So
That has not been started, Milord.
that is the
My
reason we are
stand is
telling you.
that, Milord, the university stand is that they have taken suo motu notice
Of what?
of the governor's inquiry report.
Where is that the finding? Where you have stated?
Milord,
Where you have stated? Which para of your affidavit?
Milord, that so-called notice, Milord, it is
Where?
exactly.
Tell us. That
So-called
is the
notice,
reason.
may I
Don't
read-
fumble. Tell us in your affidavit that you have filed
That so-called
in the
notice, Milord, may I
WPC
read, Milord?
the first read petition. You have filed an affidavit, right?
Yes, yes.
Where it is that you have stated?
That so-called notice itself is clear, Milord, regarding that aspect.
What?
May I read, Milord,
Read that.
so-called
Read
notice
that.
again?
Read that later.
It is in the read petition. itself,
Yes,
Milord.
yes, we are in the read petition, please.
Page 68, Milord.
Please read.
It is to Professor Rekibuddin Ahmed from Academic Register, Milord. Subject request for comments on the report received from the Office of the Honorable Governor of Assam. Sir, as directed, I am sending a copy of the report received from the experts as appointed from the Office of the Honorable Governor of Assam regarding the allegation of plagiarism in your PhD thesis. The IAIP committee, you suggest, it is only a suggestion, Milord, that your reply is to be sought on the report from your side before a final decision is taken. So, Milord, that final decision regarding initiation of
That is why we are asking
inquiry,
you
Milord,
before final.
it is in the preliminary sphere, Milord. Formal proceeding has not been started, Milord, by the
So
IAIP.
that means you cannot say that you have initiated a suo motu action.
Suo motu
First
notice,
of all,
Milord.
you should be, if you are taking a suo motu action, you have to accept the recommendation by somebody.
We have not accepted the inquiry report.
So
as
that's why
yet,
he has
Milord.
come. Take action. This is the law. This is the regulation.
That has
Take
been
it.
stated by this honorable court, Milord. That is why, Milord.
See,
That is why I am before your lordship to
Mr.
vacate
Fukan,
that
first
stay
of
order.
all, the letter that was forwarded to you from the office of the chancellor,
Milord.
it gives something else, right?
Milord.
And the university through its IAIP has forwarded a letter. First of all, either you have to accept only because it has come from the chancellor's office. You are issuing a letter to giving a point to point. Now, you are a lawyer. You are quite experienced.
Not so
Right.
experienced, Milord. Just learning.
Now,
Milord.
the thing is this, if somebody gives you something, asking you to reply before initiation of any proceeding, will you reply?
Milord, since I have
And
I
see-
have already replied on 30th June 2018 to the first round. So naturally, Milord, there is something.
Why the petitioner will give all his trump cards without initiating any proceeding? Initiate a proceeding.
There are now 3 proceedings, Milord. One FIR to total the complainants, Milord, to
That is up
so
to the complainant and the
So it
petitioner.
is-
University has
he
nothing to do.
He has filed the FIR, so criminal proceeding started, Milord. Now
That
one
is
departmental proceeding.
a different issue altogether. We are not on that.
Milord.
That affair between that complainant and the petitioner.
Arising out of the same, Milord.
Because
charges, Milord,
he
same
might say,
plagiarism
because
incident.
initially You are doing something, some complaint, and if it is during investigation, some material has been found against the person accused in the affair, it will go under the criminal procedure. We have nothing to do at this stage.
May I take your lordship to one other crucial aspect, my lord? After receipt of the inquiry report from the chancellor's office, what the university authorities will do?
Just
two options open. One,
Suo motu.
IIP.
Suo motu. Initiate suo motu proceeding.
So suo motu process.
Initiate.
Then, my lord, that misconduct aspect, my lord.
Misconduct for
Numerous-
approaching the read court.
I
That will
should
decide
not
later.
open my mouth regarding legal opinion. My lord. Numerous legal opinions have been obtained, contradictory legal opinions.
We are not on that because we are not deciding that.
Whether it
misconduct
is a
will-
double jeopardy aspect, whether university authorities should go to the misconduct.
But at
here,
least you will get hundreds of judgment that you will not able to stop anyone approaching the read court
my lord.
to defend his own rights conferred by the constitution.
But the apex court, my lord,
That is, see the background of that case.
my lord,
That is completely different with regard to this case.
it is
You take so much action,
almost
accept that report, let IIP accept that report, and initiate a suo motu proceeding against the petition.
my
You will
lord,
reply. You have the power, exercise that power.
my lord.
Who stops you?
My lord, we will have to stop that misconduct. My lord.
That is different. He is already under suspension.
That's why we challenge it by
That suspension is regarding that misconduct route, my lord.
That
The
is what I'm saying.
suspension is regarding not IIP route.
We are not on that. Initiate a suo motu proceeding against the petitioner by the II on the basis of the report submitted in the discrete inquiry.
My lord, we'll proceed with the IIP, my lord. route, my
Proceed.
lord.
If you have the power to proceed with a suo motu proceeding
But one thing
on the basis of such discrete
enters into my
inquiry,
mind,
proceed,
my lord,
proceed.
whether we should or should not proceed with the misconduct route, my lord.
Nobody has stopped against the misconduct. Is there any order passed by the court against the misconduct?
That is why we have suspended him, my lord.
Nobody has passed any order as of now.
No, I'm praying, my lord. I'm praying, my lord. I'll pray for stay of the suspension, my lord. I will reply.
We'll come back to later.
I will reply this, my lord, because your lordship, this way, that way, you know, reject it, I don't mind, my lord. But, my lord, I know as a counsel, my lord, in this court, my lord, there has to be, you have to have guts to argue for the court. Sometimes you have to say in the open court, my lord, whether it is a chancellor with great respect, whether it's a president of India, we have to tell what is the law in it, my lord. We are there to assist your lordship, my lord.
My personal
We are
opinion
there. Your
won't matter.
lordship is asking.
I have
Your
the
lordship is
guts, my
asking
lord,
10 times.
place the
And
right
if your lordship will please
law,
don't ask too much, otherwise everything will come out. So that's why, my lord, I was just hearing it quietly, my lord, I was hearing. Enough, my lord. We have also heard, my lord. What my learned, with great respect, I am telling to my learned friend, my lord. I respect my lord, my learned friend.
My lord,
But
I'm also learning
sometimes,
from him, my lord.
no,
He's senior to
sometimes,
me,
my lord, sometimes you have to be very clear on it, my lord. If there is no order, no order. If the order is illegal, we have to tell the court very frankly, this order is illegal. Set aside this order, my lord. We'll proceed further, my lord. Absolutely no problem, my lord. My lord, now conclusion is misconduct is because I have approached the honorable court. That is why there is a suspension of the order. I will, my lord, pray humbly before your lordship that this suspension orders will be stayed. If I
That
come
amounts
to
to
the court,
নিজের ভরিত নিজে কুঠার মারা,
no,
you know,
no,
the
that's
same.
not what I'm saying.
If you
my
are
lord.
saying that
And
because
I
of
know
the
it.
misconduct of the part of the petitioner,
No,
because they
that's
approached
right.
the writ court.
That's right, my
that
lord. I know
something
myself, my
different.
lord. I was very ready to argue on this. There cannot be any misconduct, my lord, on my part. And because plagiarism has not come to a logical conclusion, how they can suspend me, my lord?
The
On what
penalty
basis?
provision
Misconduct.
is there, right?
It is not regarding plagiarism. It is regarding misconduct.
What
There is a
misconduct? To
difference
what
between
extent?
Plagiarism and
Misconduct because
I have come to the court.
misconduct because
apparently, my lord,
some committee has given a
misconduct, my
report.
lord.
Some committee has given a report regarding plagiarism of the petitioner, right? In his thesis,
It is in the plagiarism sphere, my lord.
right?
But that misconduct, my lord, his conduct,
Now,
which has been deprecated by the apex court.
petitioner, instead of replying to your that notice,
Miller,
We will not say the so cause because you say there are 0.2 point.
a request letter.
Now, if you are asking the petitioner to reply 0.2 point, what do you mean by that?
Since Miller reports regarding
That means what?
% plagiarism.
It is
There are
better.
several headings, Miller.
That is better. You take a
Total
suo motu
6
action.
chapters, Miller.
You take suo motu action. Accept that report. Take suo motu action. You have the power. That's why you are
We
saying.
will have to follow the natural justice, Miller.
My lord, it has become easier now,
Then,
my lord.
then you do
Well, let
whatever
them
is
be-
required.
This
That
order
is
be
why
stayed,
apex
let
code
them do
is
whatever
clear,
they
Miller.
want.
See,
It's an academic domain, Miller.
see, basically, a person is placed under suspension when
Yes.
there is a disciplinary proceeding, right?
Miller.
Why? Because there is a possibility that he can do something with the evidence available. That's why he's kept under suspension.
Miller.
So here is a case, a thesis of the petitioner, and thesis when written 14, 16 years back prior to his doctoral thesis. Two things are in your hand. Nothing can be misutilized or this way or that way,
Miller.
right? Everything is in their book form. You have to verify. The committee, IIP of its own have to verify the report submitted by the committee constituted by His Excellency the Chancellor and the IIP. You verify. If you find anything, take action. So more.
Lord, possibly I could not satisfy your lordship regarding the preliminary steps. That
There-
request letter is
Where is that
very
preliminary
preliminary.
steps? Where is that preliminary steps? Who has to do that preliminary steps?
IIP has not been restrained to take preliminary
Take steps. Then where are you asking him to form so-called to reply point to point?
He may not be.
First, IIP has to be satisfied to issue such suo motu action,
Lord.
right? You have seen so many cases, PIL, suo motu PIL, suo motu action. The court takes action on the basis of what? The court must first satisfy of its own that there are materials to proceed against.
Lord, that EDC regulation has restrained us since it is suo motu notice, not suo motu action, Miller. That is why. Miller, we
So
will have to
why
follow
suo
the
motu
natural-
notice? First of all, something has
That-
to give you a report, right? Somebody has to give you a report
That report.
under this 2018 regulation. That yes, this is thing happening.
That inquiry report has been forwarded to the
My lord,
IIP and
my
IIP
lord,
has initiated the preliminary steps, Miller. After that, Miller, they will investigate in the matter, Miller, thoroughly.
My lord, my humble submission is that at page 86, my lord, this should be statement.
Which one?
Page 86 at in petition 8006 of 2020. Let them do whatever they want to do it, my lord. First, there is an order passed by this court. Blatantly, they have violated the court's order. Blatantly, they have violated. Page 86,
Miller,
where
I
they
have
placed
not-
me under suspension.
Miller, I have not
17/11/2022. It's my turn because I didn't disturb you.
I have not placed the authority.
No,
Miller.
it is my,
That will
my lord
clarify my
has
stand,
asked
Miller.
you, it is my writ petition. My lord, kindly
He's
see
my
page
senior,
86.
Miller, I'll have to.
17/11/2022 is the suspension order on receipt of an inquiry report from the office of the Honorable Chancellor, Guwahati University, Governor Assam, wherein it has been proved that you have indulged in misconduct or been unbecoming of a university teacher as per Guwahati University Teachers Conduct Rule, read with section 18 of so and so and a follow letter up, and you are hereby placed under suspension with immediate effect pending drawal of DP. During the period of suspension, you will be entitled to subsidy allowance so and so. So now, what it appears that this misconduct is because we have approached this honorable court, because they know they cannot place me under suspension because of plagiarism. Because these are two different things, where a logical conclusion, my lord, there is no final order of a plagiarism. Kindly see in what manner they have issued. This is Guwahati University Teacher Conduct Rule 1984. Rule 4, Roman 4 is unbecoming of a university teacher because of misconduct. I am asking myself, what is a misconduct? Misconduct is because what they have stated here, that I have approached this honorable court. This is a misconduct because I have not given one point to point of their particular letter which has been issued to me. And on this ground, you have suspended on the ground that I have not replied and I approached the Honorable Court. If that be the case, I am extremely sorry to say, my lord, this cannot be registered, cannot issue this letter. And my lord, on a kindly see on a receipt of an inquiry report from the office of the Honorable Chancellor. Now, what is that to report? My lord will kindly see. This report is based on the two individual person which is appointed by the Chancellor. And at page, kindly see at page 12, at page, sorry, page 56. Page 56, one Dr. Jagdish Arora, Professor Rajinder Kumar. And once the particularly there was two external was appointed, they have given a report that there is no plagiarism. It was placed before Guwahati University and Guwahati University has closed this, my lord. Again, it was reopened. And on the basis of that, my lord, in 2019, these two external, they have given a report. And on the basis of that report, my lord, at page 75, 23/11/2019, at page 75, Academic Register has issued his request for a comment on a report to me. I approached this Honorable Court and there was an interim order which was passed by this court. And the report is based on a second complaint which was made by one Nadeem Akhtar to the Chancellor. And on the basis of that, two experts were appointed by the governor. And total violating the regulation, 2018 regulation. Regulation speaks something else, my lord. Your lordship has gone through it. My learned friend also has read the regulation. So on the basis of that, there was an interim order passed by this court on 6/12/2019 at page 78. They were aware of the interim order on 6/12/2019. What made them not to file an application for vacating of the order? Instead, they have issued a suspension order because now it is apparent as misconduct is because of approaching the Honorable High Court. If that is the case, my respectful submission is that page 86, I humbly submit that this order should be stayed, my lord. If that be the case, and which they have argued the matter before the court. And not replying, that is against a disciplinary proceeding. So cause, if I don't give a reply to so cause, where is that? The occasion has not arisen, my lord. Your lordship has seen the regulation. There are certain procedure which has been laid down in 2018, the regulation. It starts from 6, regulation 6. However, how it has to be curbing of a plagiarism. Kindly see at page 50, my lord. So all this procedure has been laid down. Even then, my lord, that so motto it can be taken. Lordship is right. It has to be where it has to be so motto, then it has to be given to a DIP. The author, kindly see at page 51. The authority of HEI can
Will you
also
able
take
to
so
produce
motto.
the file day after tomorrow? Suspension of the file?
Yeah.
In original?
Milord.
Produce. Produce.
My lordship will hear this interim order and pass whichever this way or that way, my lord.
Two things are there.
Yes,
It's
your
very
lordship
clear.
may reject. I don't mind, my
No,
lord.
no, that's true.
That it's my absolutely his lordship discussion,
Milord,
my
I'll
lord.
place the
Produce the
authorities, Milord, later, Milord. Otherwise, Milord, I could not, Milord, able to clear the stand of the university. Why these two routes? What is the double jeopardy aspect, Milord?
My lord,
Why
I
is the
think my
plagiarism
learned
aspect?
friend also a bit of problematic is there. I know, my lord.
Read page 86. Read.
Milord, read petition, Milord.
2000, this, the fresh read petition.
8006. 8006. Last.
Last 86. That suspension order.
Hmm.
It is from
Before
register
that, you come to the previous writ petition. 2019 writ petition.
2019.
An affidavit has been filed by the respondent number 2, additional affidavit, right?
Yes.
You have a copy of that additional affidavit of the respondent number 2? Read page 155. That is Annexure H, letter of 10 September 2019.
Milord.
Read.
It is from the secretary to the governor to the vice chancellor.
Hmm.
Subject: alleged plagiarism by Professor Rekibuddin Ahmed, head, Department of Persian, Guwahati. Sir, with reference to the above, I have the honor to inform you that Register Guwahati University forwarded a report via his letter number so and so dated 19/11/2018, along with a copy of letter number so and so dated 15/11/18, addressed to the Nadim Akhtar, respondent number 9, research scholar, Center for Persian and Central Asian Studies, Jawaharlal Nehru University, New Delhi, informing him that Vice Chancellor Guwahati University constituted a committee with external experts outside the Guwahati who opined that allegation of plagiarism is baseless, unfounded, and motivated, and the Guwahati University declared the matter settled further, adding that no further complaint will be entertained. Next. However, Honorable Governor on his own constituted a committee under the chairmanship of Dr. Jagadish Arora, former Director, Information and Library Network, Net Center, New Delhi, and Professor Rajendra Kumar, Department of Persian, University of Delhi, New Delhi, to inquire the allegation of plagiarism by Rekibuddin Ahmed in his PhD thesis. The above members submitted a report which shows that there is 63.79% plagiarism in the submitted thesis, which is contradictory to your earlier information. The report is enclosed for perusal, please. Under the circumstances, you are requested to take necessary action in this regard. It is important. Under the circumstances, you are requested to take necessary action in this regard, with intimation to this office for kind appraisal of the Honorable Chancellor. This is for favor of your kind information and necessary action. It is September 10, 2019.
Now, please come to page number 68 of the writ petition, WPC 9075/2019.
(23/11/2019). It is from the academic register to Professor Rekibuddin Ahmed. Subject: request for comments on the report received from the office of the Honorable Governor of Assam. It is not so-called notice. It's a request letter. As directed, I am sending a copy of the report received from the experts as appointed from the office of the Honorable Governor of Assam regarding the allegation of plagiarism in your PhD thesis. The IAIP committee GU suggests that your reply is to be sought on the report from your side before a final decision is taken. You are expected to give a point-by-point rebuttal clarification, if any, to the points raised in the report within 10 days from receipt of this letter. Your written reply may be submitted to the undersigned. A copy to the chairman, IAIP.
Now, this particular communication, on the basis of which the petitioner alleged that another proceeding has been initiated against him, has been stayed by the court. Right? So it will be double jeopardy. Earlier there was the proceeding looked into on the basis of a complaint, and there was the second complaint, which was also looked into by the chancellor, first by the university, then by the chancellor. Now, that's why the university has asked, saying that IIP has asked to give the point-by-point report on the basis of what? the report submitted by those two experts appointed by His Excellency the Chancellor.
Milord.
Now please come to the impugned order at page
Suspension.
86, annex of 15.
Milord, next
New writ petition.
56.
86.
That suspension order. May I read, Milord? It is from register to Professor Rekibuddin Ahmed. Subject suspension order. Sir, on receipt of an enquiry report from the office of the Honorable Chancellor, Guwahati University.
Bus. What is that report?
On
23.
receipt of enquiry report.
That report forwarded by the Secretary
But
to
Supreme
the.
Court is also clear. Identical facts and charges. Two proceedings can.
Will come
proceed.
to them. Please.
Wherein it has been proved that you have indulged in misconduct unbecoming of a university teacher.
That is the misconduct.
Milord, misconduct.
Misconduct.
Unbecoming of a university teacher as per Guwahati University Teachers Conduct Rule 1984. Read with section 18 of Assam General Clauses Act. Power of appointment includes power of suspension. That General Clauses Act.
So
now, Milord,
this particular provision, this which you have action that you have initiated, have already been stayed by the court because you're not able to take any action on the basis of that.
May I read? And a follow-up letter number so-and-so dated August 12, 2022, you are hereby placed under suspension with immediate effect pending drawal of DP against you. It is not IAIP proceeding, Milord. It may be, Milord.
Where is that August 12, 2022 letter?
Milord, that is not with me right at this moment.
So the petitioner has annexed.
No,
Milord.
it is not given to us.
They have,
We
the
have asked
petitioner
for,
has
but
filed
they have
an
not
application, Milord.
We have
Milord,
asked for,
since
but they have not given to us.
Please
produce the record that will clear.
Milord.
Produce the record.
Next 3 lines, Milord, important. Is suspension order.
Please.
During the period of suspension, you will be entitled to subsistence allowance, etc., as per rule of this university. The matter is referred to the immediate next executive council meeting, and it is important, Milord. The order is issued invoking section 8(9). It is power of the chancellor, Milord, governor. 8(b)(4), power of the vice chancellor. Of the Guwahati University Act 1947, as amended up to date. So, Milord, that misconduct unbecoming of a university teacher, it is, Milord, intertwined with the General Clauses Act, Guwahati University Act, as well as the reports of the plagiarism. But it is not under the EGC regulation, Milord. It is the second route, Milord. And Guwahati University has not been restrained by this honorable court while issuing that stay order, Milord. That stay order is regarding that request letter issued by the IAI under EGC regulation. Two different proceedings. And Supreme Court is clear, Milord. Same identical facts and identical charges. Two proceedings can simultaneously commence, Milord. Simultaneously proceed.
With regard to what?
With regard to, Milord, some other fact situation,
No.
Milord. But the
In a
ratio.
criminal proceeding
but
and
the
in a
ratio
departmental
decision is
proceeding.
clear, Milord.
When there is a departmental proceeding, earlier there was a provision. If there is a criminal proceeding going on, then
No,
that will be
departmental
there.
proceeding. But the
See, that
after
doesn't-
RB Swan and that Maqbul Hussain, 5 judges constitution bench, Milord, it is clear, Milord. Both could go simultaneously.
Where?
And most
What kind of
interest-
inquiry? Either departmental inquiry,
No,
departmental proceeding.
The same charges, Milord, same identical.
Yes. Only in departmental proceeding and in criminal proceeding.
Milord, criminal proceeding is more stringent, Milord.
Earlier,
In
what
spite
was
of
the
that,
law?
Milord, both can
Earlier,
go-
what was the law?
That two proceedings cannot
Go together.
go together, Milord.
Thereafter, honorable apex have clarified.
Milord.
One is departmental proceeding, other is criminal proceeding.
Milord.
If the criminal proceeding goes on, in spite of that, the departmental proceeding can carry on the similar and identical charges. That's the law.
Milord, that beyond benefit, Milord, this standard of proof, Milord. it
So
should be
initiate
beyond
departmental
doubt.
proceeding on the basis of what?
On
That's
the
what-
on the basis of, Milord, that plagiarism report, Milord. It is
Take so
clear,
much action. Take so much action. That's why I'm telling you, take
Why
so
not?
much action.
What is the executive council meeting was held yesterday? Let him face what has happened. Executive Council meeting. This matter is referred to immediate. Let's see what the Executive Council is meeting has decided. Let it be placed. My lord,
That
because
is
it
being
is
in the
referred.
records on Wednesday.
It is been referred. My lord, I will pray for interim order. Your lordship will kindly
We pass the
consider.
order on Wednesday.
Your lordship will kindly, otherwise.
Produce
my
the
lord,
original record,
This
Mr.
day, my lord, is going on.
Produce, will not
My
pass
lord,
any
my
order.
lord, only one request. Let them produce the record, including
place
the
the
Executive
records,
Council meeting. What has happened yesterday? Your lordship will kindly note down, and prayer for interim will be considered the next day.
I may be allowed to place those, my lord, judgments of the Supreme Court.
Wednesday, you
Verify
place
the
it.
position.
Wednesday, you place.
Lordship, on the Wednesday, AG will make his necessary submit.
Whatever. Let the record be placed first.
Yes, Lord.
Based on such and such, and I'm willing to respond in the Guwahati University. To place the records in original. With regard to.
On the interim order will be considered only that way. Otherwise, my lord, it will.
File containing number GU/REGR in the case number 86 8006/2020.
And the
On the
proceeding
same
of the
day,
executive committee meeting. my lord.
the respondent university also surplays the decision of the executive council of the said university in terms of the impugned letter number such and such dated such.
Executive committee proceeding meeting also they will.
That is,
produce it.
that will come.
Yesterday it has happened, no, yesterday. So
Will not
lordship
go to
will
that
kindly note down.
extent. Let it
Your-
come. Let it.
Your lordship will note down, otherwise again they will
It is,
again take time.
I will place the records, my lord.
Yes.
All the relevant
It is
records.
stated in the bar that the executive council meeting of the Guwahati University took place yesterday, wherein,
Not yesterday, my lord, the day before yesterday,
okay, on Saturday,
Saturday. my lord. Saturday.
and the case of the petitioner in terms of the such and such was placed before the same council as such proceeding along with
It will
the
come as a motion, my lord.
our presence. It will be there.
My lord, it will come as a motion, my lord.
It will come for motion.
My lord will consider the interim prayer on that day, my lord.
Yes, Mr. Munir.
Most obliged. Item 24, my lord. Item 24, your lordship will have to give a date. We have seen the records. We have found out something.
Note it down and tell us. Have you noted down?
Yes, we have noted.
Tell us on the next day.
Yes, my lord. Any date may be given, interim order has to be extended. Well, until further order, we have been extending any date. my lord.
Malad, could it be taken on Thursday, madam?
Any date. It has to be hard finally.
It will be possible only after fourteenth. We have up to only one case as on date.
14.
14 is Tuesday.
Yes.
Make it your lordship.
My lord, interim order will come until further order.
Make
Because
me-
Just a minute. Mr. Munir,
my lord, interim
where is
order
Mr.
will
Nayak?
continue.
Yes, Mr. Nayak. That will be there, Mr. Das, don't worry. That interim order will be there.
Item number 10.
My lord, if lordship comes to page 24, my lord, of the petition. I may take your lordship to page 24, my lord, for a moment.
Yes, Mr. Nayak, but because this particular clause which you have placed is already there in the earlier order of 23rd
Yes,
of August.
now lordship, this order has been passed. First lordship, provision of honorarium, it is there. Children are to be mainstream in the neighborhood school. Lordship, after
Children are to be mainstream by
yes,
January 2023.
And third is there, it is, attendance of children. These are all consequential lordship. So important is point number 2. Children are to be maintained in the neighborhood school. In fact, lordship, there are
yes,
about 1,300 students were there, lordship, and almost 6,050 have already been mainstream. The remaining students will also be mainstream with by today. By today,
you said page 24.
My lord.
What do you want to show?
Yes, my lord, clause 6.
Hmm.
But there it says, my lord, after the proposal received from the there will be a ward education committee is approved by the district level committee. The district mission coordinator will sign an agreement with the WC, ward education committee, and the WC will sign an agreement with the candidate. Here, lordship has seen that it has been signed by the headmaster, my lord, president and the headmaster of Aziz Borua.
See, that's what Mr. Munir is asking you. This is your case, right?
Yes.
These two particulars are the WEC. You have to tell us. Where from you will tell us? Something that these two particular schools have been entrusted as a NRSTC, as a WEC. There will be some order. While obtaining this certificate, you should have also obtained that these two schools have been utilized as NRSTC.
I had telephonic conversation with my
That's the
client.
difficulty. We can always pass this order. And now thing is,
What I'm saying, that I had a telephonic conversation with my client. They have said that they, since the date of appointment, they have been signing these contracts with the school authorities, and they are being paid. And even after this contract has been signed, on 2/8/2022, they have been receiving their remuneration. They have received their last remuneration on December on the basis of this contract agreement.
yes, they will keep getting till 31st of January, lordship, this month.
up to January or up to the
January.
period of agreement?
Up to January, lord.
Now the order at page 58, is come
Up to the month of January 2023.
It says, Lakhimpur till January, by January 2023, the training centers will be closed down. That is by tomorrow.
Heard, Mr. Demonic Council appearing for the petition. BK Muni. And Ms. N. Fukan, Standing Council, Department of School Elementary Education. For the respondent numbers 1 and 3. We have also heard Mr. P. Nayak, Standing Council, SSA Assam, for the respondent number 2. By communication, number SSA/SPL dash trans TRANG /honorarium EV small s EV education volunteers DQM small s etc. /354/2011 /1849 dated 23/08/2022. The district mission coordinators wrote, the mission director, Samagra Shiksha Assam, inform the district mission coordinators of different districts, including the district of Lakhimpur, regarding non-residential special training intervention 2022-23, the training intervention training centers intervention. Clarifying that NRCC of the said district will continue functioning only till mainstreaming of the children as per the schedule specified therein, wherein 38 numbers of education volunteers required to mainstream 38 numbers of education volunteers and 29 numbers of additional education volunteers required to mainstream the students by January 2023, wherein the provision of honorarium for the NRSTC staff will be for the said period. Condition with the following the same, the district mission coordination Lakhimpur on 05/09/2022 inform the block mission coordinators of Bipuria, Bordoloni, Lakhimpur, Narayanpur, and Naupasha Education Block of Lakhimpur District about the information provided to him by the Mission Director Samagra Shiksha Assam on 23/08/2022. Informing what is DQM? Some mission, some coordinate mission or something like that. No, no. That's the thing. These are all in short, na?
Yes, sir.
Mr. Monir, what is DQM?
My lord.
What is DQM?
EQM. Lordship has found this from which page, my lord? EQM.
The order.
My lord's order, earlier order.
Anyway, we'll get it. Petitioner submitted their survey is rendering service as education volunteers on contractual basis. On being unfair, Mr. Moni, counsel appearing for the petitioners, placed copies of the agreements between the managing committee of Aziz Borwa LP School duly represented by the president and the secretary of the said school, managing committee to said school, and the petitioners number 1 to 7. to show that an agreement was signed on 02/08/2022. Whereas similar agreement,
I think that is 04 also.
hmm,
In Assamese, I think.
it should be Assamese, I think so. 2/4/2022, not 8.
This is August, my lord.
Hmm.
August, 2nd of August 2022.
We cannot
Aji
say this
Ingraji.
moment.
It says Aji Ingraji.
Can't say because either it is 2/4 or 2/8. Let them verify it.
It says Aji Ingraji, my lord.
Hmm?
Ingraji. Aji Ingraji D. 8.
Where is that? Where you are reading?
Well, first first page. First page. Second line, my lord. Aji Ingraji.
2/4. We didn't make it like
2/8,
2/8.
2/8.
Like it.
2/8,
Which is correct. We'll see to that.
2/8.
And a trigger to petition number 8 issued by same town high madrasa. Petitioner has also brought to the notice of the court that in terms of the petitioner also stated in terms of such agreement, the petitioners are serving as education volunteers. From the guidelines of opening and running of HTR or HTR center, petitioners place before the court the provision of clause C, subclause 6, Roman 6, to clause D that relates to selection process of Shiksha Kormis, presently known as education volunteers, wherein it is provided that after the proposal received from the ward education committee is approved by the district level committee, the district mission coordinator will sign an agreement with the ward education committee, and the ward education committee will sign an agreement with the candidate selected as Shiksha Kormis within bracket education volunteers. However, the petitioner submitted that they are serving in the NRSTCs of Zunaki, Junik, Gulap, Gulap, Akbar, Saporigaon, and Sanjivani. And in that regard, annexed certain certificates issued by Aziz Borua LP School, ward number 12, Lakhimpur, etc. But the petitioners have not yet placed any relevant documents to show that said Aziz Borua LP School, Lakhimpur, as well as the Town High Madrasa, Lakhimpur, I got ward number here. So 14 number one. Town High Madrasa are the concerned NRSTCs in which the petitioners are serving. That is Zigata Bharadisa. Further, petitioners have also not placed in the 11 document to show that those two schools are presently functioning as ward education committee, rendering education to the children, hard to reach children, through the present petitioners as education volunteers. Like him. Petitioners are allowed to show that such and such are the WECs and are also serving as an anesthesis in the district of Lucknow. List on 7th. Oh, yes, Ms. Fukan. Any idea?
If I may be allowed to make a prayer, madam. Till 7th, madam. So the
Questioner will not be there because it is
Yes,
already,
otherwise the
we
petition
can,
will
the
be
court will
first.
definitely able to modify that order. Don't worry.
Oh, I'll give you a blessing.
Yes, Ms. Fukan. Hmm?
Page 125.
Page 125.
This book.
Yes, yes.
Creation of personal post 21.
One page
125.
125. Yes. Yes.
Yes.
Creation of fund.
125.
Which rule?
Rule
Which
21.
section? Yes.
Section 21. Creation of personal post and maintenance of reservation policy. For the purpose of provincialization of services of the teachers and tutors under this act, the government shall create and sanction such numbers of ex-cadre posts which shall be personal to the incumbents. These personal posts shall stand abolished on cessation of the services of the teachers for any reason whatsoever, including retirement, resignation, death, etc. Since there are personal as well as ex-cadre posts, the present cadre's strength of the concerned service shall not be impacted in any way due to the creation of this post. The administrative department may retain the post of any educational institution provincialized under this act after creation of the services of the teachers which may be deemed to be necessary to run the institute. The posts so retired as per subsection 2 shall be encadred in appropriate cadre and shall continue as a permanent post. While making retention of post under subsection 2 and in creating additional posts as may be required under this act. The prescribed percentage of reservation for scheduled caste and scheduled tribes and other reservation categories as applicable under the relevant acts and rules shall be maintained.
So do you want to say that provincialization under this particular provision, section 21, which is an ex-cadre post, anyone from a recognized school can be provincialized? Or that school has to be provincialized?
Only the post shall be protected. Post can be protected.
So that way, anybody
Right.
who has not been appointed following the rules, nothing, can be provincialized or made a tutor. The reason is very clear. See,
My lord, in the regard, terms and condition is mentioned in the appointment letter, lordship, is 19, lordship. Terms and condition.
do one thing, Ms. Fukan. I'm not satisfied with the point that you have shown. Find out, because here it is very specifically mentioned that petitioner working in a school which was a recognized school, where anybody can pick up from a recognized school and his service can be provincialized as a tutor. Is it the consideration in the act? Find out. I don't think so that has been provided.
month.
I know. When? 6th, 8th, when do you want?
8 months.
8.
Allowed the income.